Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. How are you guys doing? I squeaked in just under the wire of being late. I squeaked in. How are you guys doing today? Oh my goodness. So, we've got, much to the chagrin of some viewers, we do have some election-related stuff today. There's not a lot of movement in cases. However, there is some new movement of cases. Does that make sense? No, of course it doesn't make sense. But we're going to talk about it anyway. We're going to talk about it anyway and see if we can figure some of this stuff out. Excuse me. I don't know if this is going to go the full 3 hours tonight. I'm not sure. I don't know if I have as many doom pills and black pills as you guys might be expecting tonight. We're going to talk about some other sort of things. When I talk about election news, first of all, there's no bad news today. There's no bad news today. There's only, at worst, neutral news. Green new pill. White pill. It's Schrodinger's pill right now. We don't know if it's good or bad. We don't know. But for those of you who are tired of election stuff, and in many ways I'm with you. Someone sent me a thing today, and they said, can you just talk about Vic? It was like, well, no. There's not much to talk about except twitch.tv/real Vic Mignogna. You can find it on my community tab. You can find it on a tweet. Vic is doing live streams for now. For now, I believe they are Tuesdays on Twitch around 6 p.m. Central Time. So he had one today. I assume they've got an archive of it up. I haven't looked. I wasn't able to watch. I popped in for 1 minute to call him a nerd, but I was running around dealing with other stuff. Other stuff going on. So that was, that was, there wasn't, I wasn't able to participate in that stream. But anyway, he didn't leave it up. He might not know. He might not know how. Twitch is really weird with how it does the archiving of live streams, and it doesn't automatically keep them. And until you're an affiliate or a partner, you may not even be able to keep them all that long on the system. So I miss getting called out then on Twitch. Oh, what? After I called him a nerd, did he notice it was me? That would be funny. Anyway, whatever the case is, I'm sure he and whoever is, well, he and Squally, I believe, is helping him. I don't know if anyone else is, but he and Squally will get it figured out and stuff. Why am I choppy again? That's not what is happening here. Stream just had a buffering issue, I guess. Fun times. Okay. So, let's see. Oh, but yeah, he asked me, can you just talk about Vic? And he's like, he's on Twitch. And I said, well, I did. I tweeted about it. I put it on my YouTube community page. I talked about it yesterday. There's not much more for me to say about Vic's Twitch account. I mean, again, I'll point to it today so people know and hear about it. But yeah, largely there's nothing in his case to report on. And the drama around Vic, thank goodness, is actually dying down. Because it would be really great if that man could move on with his life and not have the various drama stuff come up. And I'm not going to contribute to increasing that at a time when it looks like things are just kind of moving in a nice direction for him. I don't have any interest in bringing up drama about Vic, and I don't really see any other than some people futilely trying to tie him to, who is it? Quinton, there's another voice actor, Quinton something. Do you guys know who Quinton is? I can't remember his stupid name. Quinton Flynn? Yeah, Quinton Flynn. That's right, because it reminded me of General Flynn. Quinton Flynn was apparently not getting any traction. People have some accusations about him, but they tried to tie it to Vic's hashtag on Twitter or something. And because well, they couldn't get any attention on Quinton, so they tried to then attach it to someone that there is attention on. There are significant differences in those cases. I don't know anything about Quinton. I've never met the man, never talked to him in my life, so I couldn't tell you if he's a good guy or bad guy. Don't know. But in his case, there apparently are at least recordings of his discussions with some fans or something that some people are saying are inappropriate. I don't know. I will point out that now in a year and 10 months, nothing even close to that has been put up about Vic. I just want to point that out. In a year and 10 months, nothing even remotely close to whatever evidence they have about Quinton Flynn. And I'm not even saying that that's good stuff. Nothing even remotely close has been put up about Vic. So, you know, there's that to consider. Diamond Duck 98. Kendra when? That's a very good question. I will reach out to her because I do want to, as this election stuff is winding down, I want to start scheduling some guests on other topics. Which brings me back, thank you ADD Brain, which brings me back to why I brought up the Vic stuff in the first place, people being tired of election-related content. I did respond, I'm sorry, but the election happens to be the most critically important legal topic on Earth right now. It just is. And this is something that happens once every 4 years. And these electoral challenge crises that are going on happen once every basically never. I mean, there were 3 of them in the 1800s. There's one, sort of in Bush v. Gore, but on a smaller scope than this, it seems. So, I'm sorry, but this is ultimately like a legal news discussion channel, and this is the most important legal news that exists right now, and it's only going to exist for a period of about a month to a month and a half. So, it will be ending soon generally, but for those who are not happy with general relief from this, I will offer you specific relief. And my duty as Supreme Court Justice, Chief Justice of the Supreme Court of YouTube, and that is to say that Drexel will be here tomorrow. So we will have some discussion that is probably much less related to the lawsuit. Or to the election lawsuits. I don't know how long he's staying. I don't know, if he's going to be here through the end of the week. I don't know. We'll figure it out. We play very loose with the schedules. Not too concerned about it. But that's all I know. I just got confirmation from him that he's planning on swinging by tomorrow. So you can do that, which does mean that when he's up for it, I will be subjecting him to one of the greatest Twitch movies that exists, and that is Black Shampoo. Black Shampoo is phenomenal, and it is hotly requested to do a watch party with Drexel of Black Shampoo, so that is coming up. Also, remember, Drexel's podcast goes live on Friday, his first episode, and that is that you can find at migtown.show. That's MIGTOWN.show. Get it? Like MGTOW, but with an I and an N. .show. So you can check that out. You can go there. Yesterday, when I mentioned it, it crashed the website, which is perfect because the website thought it was a DDoS attack. So, he has a YouTube channel as well. Does he? I don't know what that is, but I think the link's on migtown.show, so you can check it out and subscribe to it. I believe the videos will be posted on YouTube. But yeah. So I'm sure we'll talk about it while he's here over the next couple days. Okay, so if you are looking for a respite from election stuff, I mean, we'll probably touch on the election, but we won't be doing these deeper legal dives into the election as we are right now. So that's okay. So that's that. On another topic, I have tentatively booked a guest for Monday's show. I'm not sure if you guys are familiar with Emily Baker. She is a YouTube lawyer as well. And she has been covering the drama in the YouTube beauty community between Toddy Westbrook? I'm sure you've seen this somewhere. Toddy Westbrook, I think, is her name. And some other person. I don't know much about it. I'll be looking into it over the weekend or whatever. It's kind of like all over the place. She's been covering it. Hopefully she's going to help me get up to speed on it. We'll talk about it. It's a defamation lawsuit involving YouTube people, which means I should be talking about it because that's funny. Vine the Cold One. Yeah, we gotta work out a time for Wang to come on. So there's that. Like I said, it's not all election content going forward. It's just that the election is prominent, important, and some people have pointed out that I've said that I think Trump's chances are really low in prevailing, and I do. That doesn't make this less important. That doesn't mean I don't want him to prevail, and that doesn't mean it's not worth talking about, because whatever the outcome is, whether Trump prevails or not, is unrelated to the critical failures and vulnerabilities in our voting system, and those being brought up in ongoing litigation in the Senate hearings. By the way, there's one coming up in Georgia, I believe, and I believe they've got one in Michigan coming up as well, and maybe even in Wisconsin. So we've got real movement on these state congressional evidentiary hearings that they're holding. Those are popping up, and having them seems to have an impact. You know, when you actually get to sit down and put the evidence forward, it seems to be having a positive impact. Now, whether or not that will actually embolden the state legislators to move on this stuff is a separate question. But that's going to tie back into something I want to talk about tonight. It's an alternative sort of possibility both ways, because I found out today that I'm a filthy centrist. It's an alternative possibility both ways on the prospect of using the legislature to either withhold electors or to appoint electors that may be contrary to or congruent with the existing popular vote. All right? So, alt-center figurehead. So, I want to talk about that, and I want to do it primarily in the context of the Supreme Court petitions being pushed in Pennsylvania. And yes, there are two of them. One of them involves the case that we just covered, which was the white pill case. Sean Parnell, Mike Kelly, and others suing, not the Trump campaign, suing over the idea that the expansion of absentee or mail-in voting was unconstitutional, right? Which the lower court seemed to agree that there's at least a valid constitutional question. They thought it so valid and, in fact, likely to succeed that they issued a preliminary injunction on perfecting the certification of the election, which is a big move. And then the Pennsylvania Supreme Court came in with a big dick power play and overturned all of that and said, nah, fam, y'all are good to go. You do whatever you want to do. We don't, that's nonsense because of laches. Well, they have appealed that to the United States Supreme Court, which may or may not hear the case. I will reiterate that I think that case has a better chance of going to the U.S. Supreme Court than, well, I mean, I shouldn't say that. Let me qualify it. I think based on the underlying case, that case has better merits than the case that the Trump campaign has petitioned before the Supreme Court. However, there are now going to be 3 Pennsylvania Supreme Court petitions, and it's possible that they will combine those into sort of one major action and dispose of all of the issues that are going on in Pennsylvania. And where I was going with this is simply here. I think it's unlikely that a legislature on its own is going to step back and withhold electoral votes or decertify an election without more, right? I do think there's a domino effect or a dam breaking effect of if any of them do it, it's sort of like they're waiting for someone to shoot first on it before anybody else does it. They want to know, because think about this from their perspective. They're laying a lot of political capital on the line with this. They're putting their political careers in jeopardy, maybe forever, if they do it. So, if they do it, they don't want to be the lone guy doing it. They don't want the lone holdout of it. So I think that if one state were to do it, other states may be emboldened to do it. But with the Supreme Court possibility coming in, it gives a sort of alternative prospect, right? It's one thing to just assemble the legislature and undo the vote. That's one very extraordinary remedy. However, the Supreme Court can order the court to do, or order the legislature to convene and pick electors, or not to, or to withhold their electors. They can invalidate votes, or they could say that the votes are so in question that the legislature is commanded to choose the electors in the manner that they decide. Now, where I say 2 ways as a centrist, is because you have two options at that point. Well, three. They can withhold the electors. They can. And they can force a constitutional 12th Amendment question. A special, a contingent election under the 12th Amendment. And I mean, if we want to read through that, we could. But that's one option. And so that just kicks the ball up to the federal legislature. If there's enough electoral votes being taken away. In Pennsylvania alone is not enough, right? So it would have to be, I believe, 3 states if one of them is Pennsylvania. But we've got challenges really in 5. Anyway, they can, in theory, do that. And then, in theory, they could withhold the votes. But the other two options are they can choose the electors who go. And they could choose electors for Trump because they say, we believe Trump validly won the election. But there's an alternative no one's really talking about. And that is the court can come in and say these votes are invalid and unlawful, right? Or they can simply say in Pennsylvania, not even that they're unlawful, but that the absentee and mail-in voting scheme in Pennsylvania violated the Pennsylvania Constitution, and therefore, that they can make that declaratory statement. It violated the Pennsylvania Constitution. The law as on the books is unconstitutional. And now we remand it to the state legislature to decide what happens. The state legislature can choose to say, we understand that the votes were unconstitutional. However, we implemented this voting scheme. And now we want to go ahead and just validate the votes as they were cast. That is another way to handle it. That's one that people aren't really talking about as much because they could. It's a Republican majority legislature. It's very possible that they could pick Trump. They could also just vote to affirm the votes that happened. They could say, we know it was unconstitutional, but we believe the people have spoken their will, and that's what we're going to do. Now, all of this to say that the U.S. Supreme Court has the unique ability, without political campaigning considerations that a state court judge has, right, to grant permission to this extreme sort of political solution, to say these votes are invalid. And now state legislators have ammunition to say, well, the Supreme Court told us that we had to decide, so we did. So that is a possibility. Will we get there? Don't know. I think tonight we're going to look at some of these Supreme Court cases, Supreme Court petitions, and there's some stuff I want to point out from one of them that when I read it made me enrage. Ethris Fox, how much is the Democratic Party paying me to say this? What would the Democrat Party get any benefit out of me saying this? Saying that the legislators could choose whichever way they wanted to go. That's silly. There's something I was reading today that made me really enrage, mainly because I now have to offer a mild apology to Trump's legal team. Although not the legal team that ended up at the hearing, whatever, in Michigan or whatever, not Rudy G, but the other legal team in Pennsylvania that pre-existed and predated Rudy's involvement by a long shot. Because I slandered them. Nasty defamatory slander when I was mad that they did not sue over the constitutionality of Act 77. And I said, man, I wish Trump's team would have done this because this is a better claim than what they've brought. What if I told you, not only did they do it, not only did they raise the constitutionality of Act 77, but they did it before the election, and guess what they were told? Guess what they were told? Because remember what the doctrine of laches is, right? Oh, you should have sued earlier. You should have sued earlier. And the counter argument to the laches was, well, if they would have sued earlier, there would be no cognizable injury. And therefore, it wouldn't be a ripe case. Well, let's see what we have here. What is this? What has happened? Okay, there we go. Let me see if I can get this pulled up for you. I figured we'd do this, and I figured we'd take a little history lesson too, because there's some interesting stuff I was reading today. Oh my goodness. One day I'll figure out how to get this thing centered right off the bat. I'll remember where my borders are. Close the furry porn. Why would anybody close it? Okay, here we go. Here we go. So this is the third. Okay, so this is the case of what is it? This is Bognet. Jim Bognet, Donald Miller, Deborah Miller, Alan Clark, Jennifer Clark versus Bookvar. This is the case we haven't really talked about too much. However, I mentioned it in the it was mentioned in the hearing with Rudy Giuliani, because they said that an order came down in Bognet which caused Rudy G and co. to drop a bunch of claims from their thing, which it did. And that's one part of this, but this is a separate part of this, and I just want to point this out, okay? Bognet is a Republican candidate for office. He, I believe, lost his re-election or his election or re-election, and he is suing. And they have, the reason I'm bringing this up is they have also requested the Supreme Court of the United States take a look at their case. Chat wants me to drink coffee, whiskey for likes, or they won't hit like. I mean, look, if they can't pull out 1,000 likes, then I'm not going to do it. I hate coffee. So, you want me to harm myself. If you, the chat, are going to bully me into self-harm with likes, you better up your like game. All right. Pennsylvania Election Code. This is page 9 of the Third Circuit Court of Appeals opinion, and this is the procedural history of all this stuff. In keeping with the Constitution's otherwise broad delegation of authority to states to regulate the times, places, and manners of holding federal elections, the Pennsylvania General Assembly has enacted a comprehensive elections code. In 2019, the General Assembly passed Act 77, which, among other things, established no excuse absentee voting in Pennsylvania. Throughout this opinion, we refer to absentee voting and mail-in voting interchangeably. All eligible voters in Pennsylvania may vote by mail without the need to show their absence from their voting district on the day of the election. Under Act 77, applications for mail-in ballots shall be processed if received not later than 5:00 p.m. on the first Tuesday prior to the day of any primary or election. After Act 77, a completed absentee or mail-in ballot must be received in the office of the County Board of Elections no later than 8:00 p.m. on the day of the primary or election for that vote to count. Okay. Pennsylvania Supreme Court decision. Notice what happens here, all right? Soon after Act 77's passage, Donald J. Trump for President, Inc., the Republican National Committee, and several Republican congressional candidates and voters brought suit against Kathy Boockvar, Secretary of the Commonwealth of Pennsylvania, and all of Pennsylvania's County Board of Elections. That suit, filed in the Western District of Pennsylvania, alleged that Act 77's no-excuse mail-in voting regime violated both the federal and Pennsylvania constitutions. This case was decided August 23rd, 2020, which means that they filed it prior to that. I don't know if y'all know this, but that's before November. That's before November. Meanwhile, the Pennsylvania Democratic Party and several Democratic elected officials and congressional candidates filed suit in Pennsylvania's Commonwealth Court seeking declaratory and injunctive relief related to statutory interpretation issues involving Act 77 in the Pennsylvania Election Code. See the Democratic Party versus Boockvar. Secretary Boockvar asked the Pennsylvania Supreme Court to exercise extraordinary jurisdiction to allow it to immediately consider the case, and her petition was granted without objection. Pending resolution, we're getting there, by the way. Pending resolution of the Pennsylvania Supreme Court case, Secretary Boockvar requested that the Western District of Pennsylvania stay the federal case. The district court obliged and concluded that it would abstain under the Railroad Commission of Texas versus Pullman Company. So they exercised abstention. They did not decide, or they did not hear the case. So there was nothing, they're not, they left it to the state court. The RNC then filed a motion for limited preliminary injunctive relief, asking that all mailed ballots be segregated. All mailed ballots be segregated. But the district court denied the motion, finding that the plaintiff's harm had, quote, not yet materialized in any actualized or imminent way. Donald J. Trump for President, Inc. versus Boockvar, Western District of Pennsylvania, September 8th, 2020. So I apologize for besmirching the good name of the Donald J. Trump for President campaign. I do apologize to them for saying they should have raised the constitutionality of Act 77 in their case. It turns out they had already done so, and they were denied because the harm had not yet materialized in any actualized or imminent way. So you can't bring it early and you can't bring it late. So I did not catch all of Viva and Barnes's live stream yesterday that they did. But the part I did catch, they did discuss sort of this conundrum, this catch-22, I think is what Viva called it, that you can't file too early, you can't file too late, and you may not even be able to file right on time. And, the way around that is what I articulated, I think yesterday as well, was saying, in essence, you file early and then get denied. And then when you file later, and they raise laches, I guess you object to it. Now, the only difference here is that they were not the same parties, right? Kelly versus Boockvar is a different case than Trump for President versus Boockvar. So, however, I don't know if they raised this in their petition for review to the Supreme Court, but I'm sure it will be brought up at some point. We can take a look at the petitions, but the Pennsylvania Supreme Court has acted wholly inappropriately here, in my opinion, based on this finding. Now, of course, this did happen in the federal court. We could take a look at it. I can actually pull up this particular case. I wish I would never be signed out of Westlaw. That would be nice. It signs you out too easy. Okay. Let me pull this up. 5407748. We could take a look at this ruling. Is that the one here? No. Oh my gosh, it's kind of a long one. Let's see. So here. Sorry, I'm just glancing through this at the funny language that's involved. Plaintiff's request for ballot segregation. First, plaintiffs asked the court to preliminarily enjoin defendants from commingling and counting, either during a pre-canvass or canvass, cast absentee and mail-in ballots that are either returned or collected through drop boxes, lack an inner secrecy envelope, or contain marks, text, or symbols thereon, or have been delivered in person by someone other than the non-disabled voters. Plaintiffs further asked that this court deem all such ballots to be challenged under the election code and direct defendants to segregate and set aside the challenged ballots in a secure location at the offices of each of the defendant county election boards. In practice, this means that all challenged ballots would be excluded from the counting in the ordinary course and subjected to a hearing procedure used for adjudicating challenges to absentee ballots or ballot applications under the statute. Presumably, plaintiffs intend to ask these ballots to be disqualified after the votes are cast if they prevail in their claims challenging the use of drop boxes. This is on their Dropbox thing. For several reasons, plaintiffs have not shown they will suffer irreparable harm if the court declines to order this relief. Here, plaintiffs cannot establish irreparable harm. Plaintiffs did not establish that they are entitled to extraordinary remedy of preliminary injunction. That is chiefly because they have not shown they will suffer irreparable harm if the court denies the injunction. Parties seeking preliminary injunctive relief must demonstrate that irreparable injury is likely in the absence of an injunction. An injury is irreplaceable only if it cannot be redressed by a legal or an equitable remedy following a trial. Further, the preliminary injunction must be the only way of protecting the plaintiff from harm. As well, preliminary relief that is mandatory rather than prohibitive will alter the status quo, must meet a higher standard of showing irreparable harm in the absence of an injunction. In such circumstances, plaintiff's right to relief must be indisputably clear. Plaintiffs argue they will suffer irreparable harm without an injunction because defendants may commingle all absentee and mail-in ballots after they are cast and collected, which, of course, they were right that they would do that, and they did it. And they did it. Once that happens, plaintiffs say there will be no way to discern which or how many of these ballots were cast in the manner being challenged by plaintiffs. To avoid this harm, they ask the court to order defendants to segregate, account for, and deem challenged all ballots within the categories plaintiffs wish to contest. All absentee and mail-in ballots return to drop boxes and retain and allow plaintiffs to periodically review video surveillance footage. Blah, 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 blah. So anyway, this is the request for an injunction. Long story short, they did challenge it. It's right here. With the federal case stayed, the state court matter proceeded. The Pennsylvania Democratic Party argued that a combination of the COVID-19 pandemic and U.S. Postal Service mail delivery delays made it difficult for absentee voters to timely return their ballots in the June 2020 Pennsylvania primary election. Pennsylvania Democratic Party claimed that this voter disenfranchisement violated the Pennsylvania Constitution's Free and Equal Elections Clause, Article 1, Section 5, and sought, among other things, a week-long extension of the deadline for receipt of the ballots cast by Election Day in the upcoming general election, the same deadline for the receipt of ballots cast by service members residing overseas. Now, in just a minute, I'm going to take you back to 1862. I'm going to take you back to the 1860s. Now, there was something going on around that time. I'm not sure if people know. Daniel Lindsay, they told them to separate a different set of ballots. Only ballots taken after, received after Election Day. Which were, postmarked by Election Day, but received afterwards, in order to be segregated. And there's not enough of those. Nowhere near. Yeah, there was a civil war going on. And what I want to do is I want to take you back to Civil War times in Pennsylvania. And we're going to talk about, we're going to read a section of a Supreme Court case of Pennsylvania. And I think it might blow your mind a little bit, the difference of opinion about voting, about judging, about election law, and about the meaning of the Constitution between then and now. Because people act like not being able to vote because of COVID, which is complete horsecockery, by the way, that COVID played any role in making voting more difficult or necessitating a mail-in scheme or anything like that. That is absolute nonsense. It is nonsensical. There is nothing true about COVID causing anything. All of the bases for this. And let's not forget that, by the way. All of the basis for the stuff that happened before the election to allow the election to be conducted in this way, no injury had occurred. No injury was even likely. They said that, well, back in June, some of the mail-in ballots for the primary didn't get out in time and then didn't get back in time. Well, what does that have to do with the November election? Why can't we fix that problem prior to November? Why is the same problem, now that we know about it, likely to occur again? None of that's likely. None of that happened. It's nonsense. So all of this happened, and unequal standards have been applied throughout. And it's really just frustrating. It's really frustrating. But I want to take you back to that sweet, sweet time of the Civil War. And while I pull that up, I would like to read a couple chats that came in. We've got Nova Zero says, another chup, ladies and gentlemen. The blank has arrived and will now perform their charge. Oh, the Inquisition has arrived and will now perform their charge. Automata says, query, are these two really incongruous? The previous decision said that plaintiffs had not incurred harm, but didn't the latter decision also do that, saying there was no harm and the challenge could only be facial? No. The latter decision said that they didn't get to the issue of harm because even if there were harm, they waited too long to bring the suit because they should have known in advance that this would cause the injury in fact, and therefore brought the facial challenge as the injury in fact, which they did, which someone else did anyway. And then it was shuffled into this other lawsuit, or these other questions about the interpretation of Act 77, which is interesting because the Republicans raised the constitutionality of the statute, and then what ended up going before the Pennsylvania Supreme Court was not the constitutionality of the statute, but it was the underlying questions about interpretation of the statute in regards to the elections and electors clause of the U.S. Constitution, whether or not they have the ability to extend the voting deadline. So, no. Now, the thing about cases from 1862 is they're written a little different, and I have to skip most of it because I don't think you guys want to read how a judge wrote in 1862. It's wholly confusing. Wholly confusing. Eagle-Lone, I'm glad Adam did well. It's wholly confusing to read. They had different issues of voting. The vote numbers were much, much smaller. Only white people were allowed to vote. You know, all of this stuff. Okay? Please read it. No, like, it's a lot of pages of very messy text. But I'm going to read you part of it. And I'll give you the background. I just want to read this specific couple sections. Okay? A couple paragraphs. I just got to find it. Let's see. Let's see. Here we go. Is this the one? All this stuff looks the same. It's a pretty volume. Here, I'll let you look at it. There's a lot of opinion in here. Let's see. I'm close. So here's what happened, okay? There was something going on called a civil war. And because there was a civil war, some of the citizenry of Pennsylvania had been sent away from Pennsylvania, okay? So they had been sent away from Pennsylvania. And what happened then, of course, is there was a vote. And there was some people who were not in Pennsylvania. Now, the Pennsylvania Constitution required in-person voting. And that is backed up by contemporary court decisions, okay? It's to actually cast a ballot in the meaning of the Constitution at the time that it was written, meant specifically to take your ballot to a balloting location and to hand it in, not by mail or delivery. Because why? Why not mail or delivery? What issue in the 1800s and early 1900s would preclude mail or other delivery of the ballot? I know it's something we've never heard of. They were concerned about fraud. They were literally concerned about mail-in ballot fraud even back in the 1800s, even back in the early 1920s when this case was reaffirmed. This is Chase v. Miller. It was reaffirmed in 1924 under a different case. So, no, you had to, in propria personae, you had to show up in person and cast your ballot. And there were no exceptions to this. Except in 1839, they passed a law. And there's a whole bunch of procedural fuckery behind this law, which prevented its enactment right away. And it ended up being enacted later, and it was utilized here. And this law established the voting recommendation. At least I think so, based on reading the gibberish earlier and the procedural background, which was admittedly boring and not relevant to what I was looking for. It's a big, long law establishing voting practices. And one section of the law, which I think is section 43, yep, the 43rd section, allows for this. The section that says the citizens referred to in its first clause, quote, may exercise the right of suffrage at any such place as may be appointed by the commanding officer of the troop or company to which they shall respectively belong. Okay? So, when we've got military away from home, and the requirements of the Constitution at the time were that you had to have 10 days domicile in the district in which you were voting prior to the election. So by 10 days prior to the election, you had to be domiciled in that district, in that voting district. All right? Now, domiciliary is a complicated and state-specific question, but the overwhelming basic rule is that you are domiciled at a place that you determine to be permanent residence, okay? And you have no intention of leaving in the foreseeable future. So when you're in college, like if you leave your parents' house and go to college, you're not technically domiciled where you're in college because you probably have a plan to return to your parents' house. You could be, like if you left your parents' house and you say, I'm going to go to this other city and live there forever, even when I'm done with college. But if you return back to your parents' house on summer breaks and you plan on going back to the same town when you're done, you're probably domiciled in the town that your parents live in, not in your college place, right? So they required you to have 10 days domiciliary prior to casting your vote on election day. Now, if you're in the military, like you're away from home, but you're going to go back home or die. That's the reality. Like if you're in the Pennsylvania military and you've marched down to Kentucky, you're not living in Kentucky. I mean, you're residing in Kentucky temporarily, but you'll eventually be planning to march back to Pennsylvania. That's how that's going to be. Okay? So, problem. Well, they're not there. So the solution that the Congress came up with was we will allow a general or commanding officer of a troop to designate a place where they can cast the vote. All right? And, yeah. And they may exercise the right of suffrage at such place as may be appointed. Now, the interesting thing is, earlier in this opinion, they point out that at such place is not defined, and so place, as it must be read in the statute, must refer to an existing voting district. Because the statute doesn't empower the commanding officer to create a voting district. And they said that that creation of voting districts is reserved to the Pennsylvania legislature. So they can't... So they're saying that the commanding officer cannot establish a voting district. He must just merely designate a voting district which exists in which they can go cast their votes. Now, if they're out of a voting district, he can't create a new one, so they can't cast their votes. And this case ultimately stems from the election for the Attorney General of Pennsylvania, and it was separated by a small enough margin that the military votes that were cast outside of Pennsylvania made a difference. They changed the election results. So that's how we got here. Okay? And so they have to resolve if these ballots cast are legal or not. If they're legal, then the one guy wins. If they're not legal, the other guy wins. Sound familiar? Right. It should sound familiar because that's literally what's happening here. Okay? So we've got, this is the provision they're discussing. So the part I want to read to you, though, starts about here because we have a similar thing going on right now. The idea is that COVID has created this extraordinary circumstance that will prevent people from voting, which again, I submit is bullshit. However, that's the narrative. Unless we give them this mail-in and absentee voting, no excuse mail-in and absentee voting that was passed by the legislature. So the arguments today are that invalidating these votes would be an extraordinary remedy because that would disenfranchise voters, right? Let's see what they said about disenfranchising voters in 1862. Now, in 1862, we have what I would consider a much more extraordinary circumstance in the Civil War, right? Much more extraordinary than COVID-19. A whole lot more going on with that. And then we also have a different class of people. We have military soldiers who are taken away from their homes to serve in the military being denied the vote. So this isn't just someone who's like, oh, I'm scared to go to the grocery store, I better absentee ballot. This is a soldier who has volunteered or been conscripted, but I believe it was a volunteer military force from Pennsylvania, who's volunteered to serve their country and is thus not able to be physically present. There is no way for them to get from where they are because they had to march or ride a horse in time for this election to happen. They have duties that prevent them from doing this, right? So, comparable enough situations, in my opinion. All right. Stick with me on this. Now we have seen above that the Constitution prescribes a place. Wait. This is the place discussion here. Legislature did not authorize it. Okay. A constitutional argument which rests on such assumptions can never be formidable. When a soldier returns to his election district, he resumes all the civil rights of citizenship and his residence being unimpaired by his temporary absence. He has a right to vote on election day, but under the Constitution, to which his fealty is due, he can acquire no right to vote elsewhere, except by a change of residence from one district to another. The repugnancy of the 49th section to other sections of the same statute is as gross as its inconsistency with the Constitution. It says the citizens of this Commonwealth, qualified as hereinbefore provided, shall have the peculiar right of suffrage, which is claimed in this case to be constitutional. The word hereinbefore is a reference to prior sections of the same statute, but the qualifications for suffrage are not contained in any prior section. Another instance of careless legislation. It is not till we get to the 63rd section that we come to the subject of qualifications. The 63rd section reenacts the first section of the 3rd article of the Constitution in terms. If we read the word hereinbefore as it were written hereinafter, or if we construe it as referring to the constitutional clause of qualification, and in one or the other of these ways it must be taken, it comes to the same thing: a demand for the constitutional qualifications of suffrage in every soldier who claims to vote under the 43rd section. It says, in effect, that the soldiers who offer to vote in the election district wherein they have resided 10 days immediately preceding the election shall be entitled to vote in any place their commander appoints, provided it be not within 10 miles of the district where they have resided for the last 10 days, which is downright nonsense. Yet such is the effect of the words qualified as hereinbefore provided. When taken in connection with the other parts of the section, they turn the whole section into jargon. Where is it? Let's see. Here we go. It is scarcely possible to conceive of any provision in practice that could at so many points offend the cherished policy of Pennsylvania in respect to suffrage. Our Constitution and laws treat the elective franchise as a sacred trust, committed only to that portion of the citizens who come up to the prescribed standards of qualification, and to be exercised by them at the time, place, and manner prearranged by public law and proclamations, and whilst being exercised, to be guarded down to the instant of its final consummation by magistrate and constables, and by oaths and penalties. All of which the 43rd section reverses and disregards, and opens a wide door for most odious frauds, some of which have come under our judicial cognizance. It is due to our citizen soldiery to add, however, in respect to the cases of fraud that have been before us, that no soldier was implicated. The frauds were perpetrated in every instance by political speculators who prowled about the military camps watching for opportunities to destroy true ballots and substitute false ones, to forge and falsify returns, and to cheat citizen and soldier alike out of a fair and equal election provided for by law. Let's see. Where is... I'm missing the particular section. Hold on. Let's see. I've got to find this one particular section, and I apologize. I was looking at it on my phone, so I don't have it here. Here it is. Okay. I know this is discombobulated, but stick with me. Stick with me, I beg you. Because I want you to see how they valued the voting system and the difference that we have today in what we're talking about with votes. Here we see the definition of a voter growing more exact, and in the Constitution of 1790 still more exact, and finally in that of 1838, he is to superadd to the other distinguishing marks a district residence of 10 days immediately preceding the election. Now, the labor of the Constitution has not been to restrict suffrage in any spirit of distrust of popular intelligence, but it has been to define it so exactly that it might be preserved from abuse and perversion. The Constitution affords ample grounds for judicial implications in favor of legislation that tends to ascertain legal voters and votes with precision and exactitude, but not an atom of ground for implications in behalf of a law that opens the ballot box anywhere and everywhere. Under supervision of military officers, wholly unknown to our civil administration, and where no officer can possibly be who is specially charged with the supervision of state elections. Because judicial implications have been set up in behalf of other acts of assembly, it does not follow that judicial implications can save this one. In other instances, the implication was well grounded in the Constitution. In this instance, everything in the Constitution forbids the implication. Okay, so they're saying that the vote is so sacred, basically, and so important and critical a right that the Constitution has defined it to only allow people who rise to the heightened expectation of qualifications to become a voter, to be a voter. And part of that expectation is the place in which you're at and the domiciliary, right? What they're saying, though, is that the Constitution cannot, by its terms, disenfranchise a voter. It can't disenfranchise a voter because it is the enfranchisement of voters. That's what's in the Constitution. So to say it disenfranchises a voter would say that there is some superseding authority that defines what the voter is and that the Constitution limits that authority. It can't by its terms do that because the Constitution is what defines what a voter is in the first place. Okay? So any argument that not allowing absentee ballots today, if you were to apply that today, not allowing absentee ballots because it's not in the Constitution disenfranchises absentee voters is nonsensical. Because the definition of what a voter is and how a voter acts is in the Constitution. That is the enfranchisement. Does that make sense? I hope so. Okay. The learned judge deprecates a construction that shall disenfranchise our volunteer soldiers. It strikes us that this is an inaccurate use of language. Okay, so they're talking about the judge below. The judge below the Supreme Court said that this disenfranchises soldiers by not allowing them to vote. All right? If it were not upheld. The Constitution would disenfranchise no qualified voter. but to secure purity of election, it would have its voters in the place where they are best known on election day. If a voter voluntarily stays at home, or goes a journey, or joins the army of his country, can it be said the Constitution has disenfranchised him? 4 of the judges of this court, living in other parts of the state, find themselves on the day of every presidential election in the city of Pittsburgh, where their official duties takes them and where they are not permitted to vote. Have they a right to charge the Constitution with disenfranchising them? Is not the truth rather this, that they have voluntarily assumed duties that are inconsistent with the right of suffrage for the time being? Such is our case, and such is the case of the volunteers in the army. The right of suffrage is carefully preserved for both them and us, to be enjoyed when we return to the places which the Constitution has appointed for its exercise. It is forcing a gratuitous assumption upon the Constitution to treat it as intending that the volunteer in the public service shall carry his elective franchise with him wherever his duties require him to go. There is no word or syllable in the instrument to justify the assumption. So, yet again, we have this idea that the Constitution, by terms, cannot disenfranchise a voter. It defines what a voter is and how they carry out their sacred duty. Notice the difference in thinking of this is why I'm reading this. One, this case is cited by the Republicans, by the Parnell petition, okay? This is the basis of their case. It goes all the way back to 1862, reaffirmed in 1924. We're going to look at that in a second. But this is the basis of their petition to the Supreme Court and why they say that Act 77 is unconstitutional on its face. So that's why we're doing this. But I want to point out the differences in thinking of the judiciary back then. Judiciary has no fucking chill on this. They say, oh, I'm sorry that the military isn't there to vote, but they chose to join the military, voluntarily leaving the state, knowing that they will not be able to vote. Their right to vote isn't infringed by that because their right to vote still exists. Their right to vote exists as defined in the Constitution. And that is a critical argument that we have flat out fucking ignored for the past, I don't know, at least 4 years, if not longer, where we now hold the right to vote as personal and mobile. But the right to vote may not be that. I don't have some ephemeral or non-corporeal right to vote, right? Some weird theoretical. It's a concrete right that is defined by terms set down in law. Those terms are what give me the right. It's not something I hold. And this is brought up at the confirmation hearings of Amy Coney Barrett. The difference between a personal and a civic right. The personal right to bear arms versus the civic right of the vote. The personal right is something that is inherent to you. It is held within your person wherever you are. The right to bear arms, the right to self-defense, the right to life, liberty, and property, that is all carried with you no matter where you are at all. It is not conferred upon you by the state. The right to vote is not an inherent and natural right. That is a right created by the state and conferred upon the citizenry. And we have, I don't know, through probably 80 years of indoctrination, changed the idea that the right to vote is some sort of thing inherent to us. But if you go somewhere else to a different voting system, for example, you don't have a right to vote. You don't have a right to vote. You do have a right to life wherever you are. That's an inherent and alienable right. Your right to bear arms is too, as recognized by our Constitution. That's not conferred upon you by the Constitution. That's recognized by the Constitution as an existing right, and the state has no ability to infringe upon that right, in theory, right? US v. Miller threw that shit out the window. But your right to speak, your right to religion, these are personal rights that are inalienable from you. If a government is imposing upon those rights, it is an injustice. It is a recognition that it is stepping into your space and depriving you of a right that you hold. The right to vote isn't that. At least not recognized by our system of governance. Okay. So, here we go. This is the next section. A good deal has been said about the hardship of depriving so meritorious a class of voters as our volunteer soldiers of the right of voting. As a court of justice, we cannot feel the force of any such consideration. Oh. Our business is to expound the Constitution and laws of the country as we find them written. We have no bounties to grant to soldiers or anybody else. It may be said, however, in answer to this suggestion, that the hardship of missing an annual election is one of the least the soldier is called on to endure. And this they share in common with the patriot soldiers of all the loyal states, for it is understood that no state but Pennsylvania has attempted to extend civil suffrage to an army in the field. To voluntarily surrender the comforts of home and friends and business, and to encounter the privations of the camp and the perils of war for the purpose of vindicating the Constitution and laws of the country is indeed a signal sacrifice to make for the public good. But the men who make it most cheerfully and from the highest motives would be the very last to insist on carrying with them the right of civil suffrage, especially when they see what experience proves that it cannot be exercised amidst the tumults of war without being attended with fraudulent practices that endanger the very existence of the right. While such men fight for the Constitution, they do not expect judges to sap and mine it by judicial constructions. Finally, let it be said that we do not look upon the construction we have given the constitutional amendment as stringent, harsh, or technical. On the contrary, we consider it the natural and obvious reading of the instrument, such as the million would instinctively adopt. Constitutions, above all other documents, are to be read as they are written. Judicial glosses and refinements are misplaced when laid upon them. Carefully considered judicial implications may indeed be made from them in support of statutes, never to defeat statutes, when such implications are grounded in the Constitution itself and tend to accomplish its obvious purposes, as well as to promote the public welfare. But when asked to set up a construction that opposes itself to both the letter and the spirit of the instrument, and which tends to the destruction of one of our fundamental political rights, that free and honest suffrage on which our institutions are built, this court must say, in fidelity to the oaths we swore, that it cannot be done. Damn. So, this is a serious divergence from modern thinking about what a vote is, what a constitution is, what judges' roles are in handing this out, in determining what the Constitution says. And the Pennsylvania Supreme Court back in 1862 flat out said, you know what? Yeah, some people aren't gonna be able to vote because they chose to go to war. But you know what? The Constitution doesn't allow it. It doesn't permit voting away from home. It just doesn't in any case. And so, going further to say that bringing this up to the modern era, the Pennsylvania Constitution was amended in 1968 to allow for limited absentee voting. 4 distinct classifications of absentee voting, in 1968 being the most recent amendment concerning it. And you can check that out. It's Pennsylvania Constitution Article 7, paragraph 14, section 14, something like that. And it lays out what absentee voting is. So the argument ultimately comes down to, is it constitutional to pass a law that changes absentee voting outside, or that expands absentee or mail-in voting outside the bounds of the Constitution? I think the Republicans competently argue that the case law the history of the Pennsylvania Constitution and how the election provisions have been interpreted from jump are to say that it is impermissible to expand absentee or mail-in voting, that it is not permissible outside of a constitutional amendment. All right. So that is very big. That is very big. Let's pull up the Republican petition in Kelly versus Bakvar. Now Kelly versus Pennsylvania, apparently. Okay. So this is the case we were talking about the other day with Sean Parnell listed, Mike Kelly, Thomas Frank, Nancy Kierzik, Derek McGee, Robin Souter, Michael Kincaid, and Wanda Logan. Bad Vibe says, interestingly, all these shenanigans of the three branches of government is going to cost them politically regardless of what happens. If all three are toothless to balance the others and media carrying one party, there will be chaos. I agree. Bad Vibes also says, in other words, being a voter is literally an act of Congress, not God. Yes. Yes. It is, well, more appropriate. Yeah, no, it is. It is the state legislatures who enact the right to vote. The federal Constitution has no individual right to vote. Farah's 181, I think you're misunderstanding what's going on here. U.S. troops serving abroad aren't at their domicile, and if I truly believe in denying these troops the right to vote, then that's your hill to die on. I don't believe in denying them the right to vote. The right has been expanded in basically every state to allow for the absentee voting of military. The right is defined by either the legislature through state statute or by the legislature through state constitutions. Pennsylvania has created an absentee exception, and one of those absentee exceptions is the military. So no, there's no argument that the military of today shouldn't be able to vote. They have ways to secure the military vote that they are confident enough in to amend their constitution. That's fine. However, what we don't have is an amendment to the Constitution to allow no excuse absentee or mail-in voting in Pennsylvania, and that's what happened in the election. That's what makes it unconstitutional. So there you go. Please don't be misunderstood. The idea is that who a voter is and how a vote is exercised is enshrined in law. And we need to follow that law. And it is actually a disenfranchisement and a dilution of that right to allow anything else but what is defined to exist. So this is the petition of the... goodness gracious. I'm trying to get this thing there. This is a petition to the United States Supreme Court in the case about Act 77 that was, remember, this is when the Pennsylvania Supreme Court came in and at 10 p.m. on Sunday struck down the injunction. So this is an emergency application for writ of injunction pending the filing and disposition of a petition for a writ of cert. To the Honorable Samuel Alito, Jr., Associate Justice of the Supreme Court of the U.S. and Circuit Justice for the Third Circuit. So they petitioned Samuel Alito, and he has considerable say in whether or not this will be heard. This was that thing people were talking about where gosh, it's like just a hair too big, where the justices were assigned different circuits. Alito is in charge of the circuit where Pennsylvania sits, the Third Circuit, and therefore Alito will be answering emergency petitions. Now, Alito is one of the judges who told Pennsylvania to segregate ballots. So that is promising. It doesn't really say for sure anything about it, but it is promising. So the questions presented: may a legislature violate its state constitution's restrictions on the lawmaking power when enacting legislation for the conduct of federal elections pursuant to Article 1, Section 4 and Article 2, Section 1 of the Constitution? So, framed as, can the Pennsylvania legislature pass an unconstitutional, under Pennsylvania Constitution law, making, bypassing the constitutional restrictions when enacting legislation for a federal election? This is something that has been, and it's been overlooked a little bit by me. I've mentioned it a couple times, but I probably haven't mentioned it enough. The Supreme Court can take any of these state law cases that implicate a federal election under Bush v. Gore. Whether or not they will is a different question, but they have the legal authority to do so. Under Bush v. Gore, they basically said, a state law question that implicates a federal election, the Supreme Court has jurisdiction over. So they have the tools to do it. Whether or not they will use those tools is up to them. Did the Pennsylvania Supreme Court violate petitioners' rights under the First and 14th Amendment of the United States Constitution by dismissing with prejudice the case below on the basis of laches, thereby foreclosing any opportunity for petitioners to seek retrospective and prospective relief for ongoing constitutional violations? Very good question. Very good question. They have Kelly versus Commonwealth in both of these below. I think they should have incorporated Bognet, and I don't know if they can. I'm not an expert on this, on the related proceedings, if they can incorporate proceedings that they're not party to. Probably not, but I think the court will be asking the question of whether they can combine these issues. All right, so I'm going to skip through the procedural background for the most part of this because, well, we'll read this. This is them. This is their petition. Applicants respectfully request an immediate emergency writ of injunction to prevent the respondents, the Commonwealth of Pennsylvania, Governor Thomas Wolfe, and Secretary of the Commonwealth, Kathy Boockvar, from taking any further action to perfect the certification of the results in the November 3rd general election in Pennsylvania for the offices of President and Vice President, or certifying the remaining results of the election for U.S. Senators and Representatives. More specifically, petitioners seek an injunction that prohibits the executive respondents from taking official action to tabulate, compute, canvass, certify, or otherwise finalize the results of the election as to the federal offices, and that prohibits the executive respondents from undertaking the following actions. So prohibiting them from doing these actions. I'm not going to read through them. This part's interesting. To the extent that the above prohibited actions have already taken place, petitioners seek an injunction to restore the status quo ante, compelling respondents to nullify any such actions already taken until further order of this court. Petitioners also ask the court to consider this application as a petition for cert, grant cert on the questions presented, treat the application papers as merits briefing, and issue a merits decision as soon as practicable. So this is their petition for cert, petition for injunction, and their brief on the case, all in one. They don't want any sort of briefing schedule for themselves. There will obviously be a responsive briefing schedule, but they don't want anything. If the court takes up the case, they don't want any delay on their own end. They want this to happen as fast as possible. So intro, this is Act 77, the no excuse ballot scheme. I'm going to skip through most of this because you guys, I believe, know what we're talking about. With Act 77. They've begun the steps necessary. So decisions under review. November 28th, 2020 decision of the Supreme Court of Pennsylvania dismissing all of petitioner's claims with prejudice, along with concurring and dissenting statements, are reproduced as Appendix A. Constitutional and statutory provisions involve. This case involves U.S. Constitutional Article 1, Section 4, Clause 1, the Elections Clause, Article 2, Section 1, Clause 2, the Electors Clause, Constitution Amendment 1, Petition Clause, Constitution Amendment 14, Due Process, all applied at the appeals page 68 and 69, or all appended at appendix page 68 and 69. Factual and procedural background. Here we go. Petitioners initiated this action by filing a verified petition for review. Wait, we read all this in the lower court stuff. I'm going to skip this. This talks about their horse-cockery, where they were ordered by the court to respond, and instead of responding, what they did was they just went ahead and tried to perfect the election, or tried to certify the election, at least as far as the president, to make the issue moot. Here's the factual background about the amendment. Here's the in-progress efforts to amend the Constitution, which we've talked about in the other cases. So I'm skipping this to the new stuff, the new Supreme Court arguments, because that's where we want to go. So here's Act 77 and Act 12 of 2020. The November 3rd election was held. Go, boring. Reasons for granting the application. Okay. The All Writs Act 28 U.S.C. 1651A authorizes an individual justice or the full court to issue an injunction when 1. The circumstances presented are critical and exigent. Pretty hard to argue that they're not critical and exigent, right? The circumstances must, like, there is no, it's hard to fathom a more critical thing than the presidential election is happening in 12 days. The electors are happening in 12 days. 2, the legal rights at issue are indisputably clear. And 3, injunctive relief is necessary or appropriate in aid of the court's jurisdiction. 1 and 3 are done. The legal rights at issue are indisputably clear would be the question. Are they indisputable? I think they are, but that would be the big question here. 3, injunctive relief is necessary or appropriate in aid of the court's jurisdiction. The court, if the court is going to take up this case, they should execute the injunction and prevent any further harms. Alternatively, pursuant to 28 U.S.C. 2101F, this court may stay the execution and enforcement of such judgment or decree for reasonable time to enable the party aggrieved to obtain a writ of cert from the Supreme Court. It would be reasonable for this court to stay the Pennsylvania Supreme Court's vacatur of the Commonwealth Court's preliminary injunction until this court can make a determination on petitioner's petition for a writ of cert. An injunction in this case is essential to protect the integrity of the November 3rd general election and prevent further irreparable harm to petitioners' federally protected rights. The standards for injunctive relief are satisfied, and if this court does not intervene, the executive, respondents, and electors will take further actions to certify the results of the election, potentially limiting this court's ability to grant relief in the event of a decision on the merits in petitioner's favor. Granting emergency relief is also necessary to avoid irreparable injury to the voters of Pennsylvania and to the petitioners from the resulting wrongs of an election conducted pursuant to an unconstitutional and invalid no-excuse absentee voting scheme. Petitioners seek relief for violation of their due process rights and rights to petition under the 14th and First Amendments to the U.S. Constitution, affected by the Pennsylvania Supreme Court's decision. Pennsylvania's General Assembly exceeded its powers by unconstitutionally allowing no-excuse absentee voting, including for federal offices in the election. The opinion below forecloses any means of remedying petitioners' injuries. This court has many options available to it in providing a remedy for when an election is found to have been conducted illegally. The United States form of constitutional governance, embedded with the principles of comity, federalism, and the separation of powers, allows this court to leave to the political branches, or even instruct them to provide remedies for certain harms found here. For the state races, Pennsylvania's Constitution and Election Code provide the political branches with the necessary tools to overcome contested elections and ensure that no voter is disenfranchised by their prior failure in enacting Act 77. With respect to elections for federal office, both state legislatures and the Congress have specified roles inscribed in the Constitution as fail-safes for state failures in conducting elections. Importantly, any remedy fashioned by this court must also recognize that upcoming deadlines for the seating of elected office holders impose an urgency for this court to act. See 3 U.S.C. Section 5, Federal Safe Harbor deadline for resolving election controversies in order to ensure a state's electoral college vote are counted. 3 U.S.C. 16, the date of the joint meeting of the two chambers of Congress where the result of the electoral votes are declared is set to take place on January 6, 2021. Okay. The power delegated to the Pennsylvania General Assembly by the U.S. Constitution to determine the manner of holding federal elections and select presidential electors is constrained by restrictions imposed by the Pennsylvania Constitution. The U.S. Constitution delegates the power to determine the manner of holding federal elections and to select presidential electors in Pennsylvania to the Pennsylvania General Assembly. Article 1, Section 4 of the U.S. Constitution provides these are the time, place, and manner of holding electors for both the senators and representatives and then the president down here. In exercising those delegated powers, the General Assembly is constrained by restrictions imposed onto it by the Pennsylvania Constitution. What is forbidden or required to be done by a state is forbidden or required of the legislative power under the state constitutions as they exist. Smiley versus Holmes says, citing McPherson and noting that state legislatures are constrained by restrictions imposed by state constitutions on their exercise of the lawmaking power, even when enacting election laws pursuant to U.S. constitutional authority. And then citing Arizona State Legislature versus Arizona Independent Redistricting Commission, holding that redistricting is a legislative function to be performed in accordance with the state constitution's prescriptions for lawmaking, which may include referendums. As a general rule, this court defers to a state court's interpretation of a state statute. But in the case of a law enacted by a state legislature, applicable not only to elections in state offices, but also to the selection of presidential electors, the legislature is not acting solely under the authority given to it by the people of the state, but by virtue of a direct grant of authority made under Article 2, Section 1, Clause 2 of the United States Constitution. And this is Bush versus Palm Beach County Canvassing Board, otherwise known as Bush v. Gore. This says that if there is a federal election involved, it is a federal question, even if it's only a question of state law, and that the Supreme Court can exercise jurisdiction. So here we have a case that went through the Pennsylvania state courts. Now it is a question of federal law for the Supreme Court. Bad Vibe says, by their powers combined, someone is getting fooked. When a state legislature violates its state constitution, purportedly in furtherance of its plenary authority to regulate federal elections and appoint electors, it also violates the U.S. Constitution. Quote, I got something in my throat. I feel like a OnlyFans thought. Quote, a significant departure from the legislative scheme for appointing presidential electors presents... What the hell? Oh my God, I'm dying. I can feel it in my throat. Let me try again. A significant departure from the legislative scheme for appointing presidential electors presents a federal constitutional question. Bush v. Gore. In-person voting is a criterion for qualifying to vote under the Pennsylvania Constitution, subject only to specified absentee voting exceptions. Article 1, Section 4 and Article 2, Section 1 grant plenary authority to state legislatures to enact laws that govern the conduct of elections. Yet, while the legislature may enact laws governing the conduct of elections, No legislative enactment may contravene the requirements of the Pennsylvania or United States Constitution. Kaufman versus Osser. At issue here is the Pennsylvania General Assembly's attempt and success, if this court should not hear this case, in implementing by legislation a no-excuse absentee voting system for state and federal elections that violates the Pennsylvania Constitution and U.S. Constitution. Under 158-year-old Pennsylvania Supreme Court precedent, voting in person at the election in the district for which a voter is registered is a qualification for voting under the Pennsylvania Constitution. See Pennsylvania Constitution, Article 7, Section 1, Chase v. Miller, that's what we read earlier from 1862, an in-RE contested election in 5th Ward of Lancaster City, that's in 1924. The current Pennsylvania Constitution sets out the following qualifications for voting: 18 years of age or older, citizen of the United States for at least 1 month, residence in Pennsylvania for the 90 days immediately preceding the election, and has residence in the, quote, election district where he or she shall offer to vote at least 60 days immediately preceding the election. That's from the Pennsylvania Constitution, Article 7, Section 1. This is where they're getting the requirement to vote in person. They've emphasized it here, but they're going to explain why that says something other. Why shall offer to vote means shall show up in person, which is a very, very important distinction, because shall offer to vote on just a reading of it doesn't seem to mean anything else. But it doesn't matter what the reading of it now means so much as what the reading of it meant at the time the Constitution was implemented, and we will find that out in just a minute. For the orderly exercise of the right resulting from these qualifications, the legislature must prescribe necessary regulations, but this duty and right inherently imply that such regulations are to be subordinate to the right. As a corollary of this, no constitutional qualification of an elector can in the least be abridged, added to, or altered by legislation of the pretense of legislation. So the constitutional qualifications cannot be abridged, added to, or altered. They are the qualifications. Citing in RE contested election in 5th Ward of Lancaster City. So now, here we have Chase v. Miller and Lancaster City working on this offer to vote language. To offer to vote by ballot is to present oneself with proper qualifications at the time and place appointed, and to make manual delivery of the ballot to the officers appointed by law to receive it. The ballot cannot be sent by mail or express, nor can it be cast outside of all Pennsylvania election districts and certified into the county where the voter has his domicile. We cannot be persuaded that the Constitution ever contemplated any such mode of voting, and we have abundant reason for thinking that to permit it would break down all the safeguards of honest suffrage. The Constitution meant, rather, that the voter in propria persona should offer his vote in an appropriate election district, in order that his neighbors might be at hand to establish his right to vote if it were challenged, or to challenge if it were doubtful. Our Constitution and laws treat the elective franchise as a sacred trust, all of which the 1839 Act reverses and disregards, and opens a wide door for most odious frauds, some of which have come under our judicial cognizance. So, again, they're saying that this specific language, offer to vote, means right here to present oneself with proper qualifications at the time and place appointed. So that is the in propria persona requirement. That's where it's derived from the offer to vote language, which still exists in the Constitution today. Shall offer to vote. They've had the opportunity to amend this. They have amended the Constitution since this decision, and they have not removed this phrase. This is a very, very good argument. Article 7, Section 14A provides the only such exceptions to the in propria persona voting requirement of the Pennsylvania Constitution in 4 specific circumstances. It states, A, the legislature shall, by general law, provide a manner in which and the time and place at which qualified electors who may on the occurrence of any election be absent from the municipality of their residence because of their duties, occupation, or business require them to be elsewhere, or who, on the occurrence of any election, are unable to attend at their proper polling places because of illness or physical disability, or who will not attend a polling place because of the observance of a religious holiday, or who cannot vote because of election day duties, in the case of a county employee, may vote and for the return and canvass of their votes in the election district in which they respectively reside. So, if you have duties, occupation, or business, you can basically provide these 4 exceptions. That's how it worked prior to 2019. Well, 2020 was the first year that this happened. You could provide these exceptions in your application for an absentee ballot. Your duties: I'm in the military, I can't be there, I request an absentee ballot. Okay, done. The legislature shall provide a manner for these things to happen. Outside of these 4 enumerated exceptions, the Pennsylvania Constitution prohibits absentee voting. Act 77 is illegal and void ab initio because of the General Assembly does not have the authority to enact legislation in contravention of the powers delegated to it by the Pennsylvania and U.S. constitutions. The legislature can confer the right to vote only upon those designated by the fundamental law and subject to the limitations therein fixed, citing Lancaster City. Act 77 unconstitutionally expands the scope of absentee voting to all voters in contravention of the Pennsylvania Constitution. Act 77, as amended, defines a qualified mail-in elector as a qualified elector. A qualified elector is, quote, any person who shall possess all of the qualifications for voting now or hereafter prescribed by the Constitution of this Commonwealth, or who, being otherwise qualified by continued residence in his election district, shall obtain such qualifications before the next ensuing election. In short, Act 77 qualifies all electors as mail-in electors. Moreover, newly created statute states qualified mail-in electors, general rule, a qualified mail-in elector shall be entitled to vote by an official mail-in ballot in any primary or election held in this Commonwealth in the manner provided under this article. In construction, the term qualified mail-in elector shall not be construed to include a person not otherwise qualified as a qualified elector in accordance with the definition in Section 102T. Separately, absentee voting is defined in a separate statute which outlines a variety of categories of eligibility that are each consistent with Article 7, Section 14 of the Pennsylvania Constitution. So mail-in electors are defined legally different from absentee electors. While Act 77 purports to create a distinction between the existent absentee voting and mail-in voting, there is no distinction, except that mail-in voting is simply absentee voting without any of the inconvenient conditions precedent that the Pennsylvania Constitution requires. Bad Vibe says, what is the over-under on the SCOTUS handing down a writ of mandamus if they rule on the appellant's behalf? I don't think they'll have to mandamus anything. They'll just vacate, they'll vacate the vacatur of the underlying injunction, and they'll reinstate the injunction. I don't think there's a mandamus requirement because there's an existing legal remedy that doesn't require mandamus. Lius 9 Lives asks if it was possible some of these issues could have been investigated and dealt with in order to prevent so many post-election lawsuits. Not all of it, but once mail-in confirmed. Yeah, except they were told they couldn't. You might have missed that part of the stream. The Trump campaign actually sued on this very act, stating it was unconstitutional, and was told that they didn't have an injury yet. So they weren't allowed to sue prior. The Pennsylvania Supreme Court in Chase v. Miller struck down unconstitutional military absentee voting during the Civil War. Pennsylvania was one of the first states in the nation to allow for absentee voting, originating with the Military Absentee Act of 1813, which allowed members of the state militia and those in service of the United States to vote as long as a company of soldiers was serving the soldier was serving was more than 2 miles from his polling place on election day. At the time the Military Absentee Act was passed, the Pennsylvania Constitution imposed no restrictions with regard to absentee voting. However, in 1838, Pennsylvania amended its constitution to require voters to reside in the election district where he offers to vote 10 days immediately preceding such election. This created a conflict with the Military Absentee Act as reenacted in 1839, which allowed for absentee voting, and the newly amended Pennsylvania Constitution, which no longer did. In the 1861 election, Pennsylvania soldiers voted under the Absentee Act of 1839, and legal challenges came soon after. In 1862, the Pennsylvania Supreme Court decided Chase v. Miller, analyzing the constitutionality of the Military Absentee Ballot Act of 1839 under the Pennsylvania Constitution. The Pennsylvania Supreme Court held that the act was unconstitutional because the purpose of the constitutional amendment was to require in-person voting in the election district where a voter resided at least 10 days before the election. Following the Pennsylvania Supreme Court's invalidation of the 1839 Military Absentee Voting Act, Pennsylvania General Assembly amended the Constitution in 1864 to include for the first time a provision allowing for absentee voting by active military personnel. From 1864 to 1949, only qualified electors engaged in actual military service were permitted to vote by absentee ballot under the Pennsylvania Constitution. However, this limitation did not prevent the legislature from, again, attempting to pass unconstitutional legislation to expand absentee voting. In 1924, the Pennsylvania Supreme Court decided Lancaster City, striking down as unconstitutional the Act of May 22, 1923, providing civilians the right to vote by absentee ballot. Quoting Chase, the Pennsylvania Supreme Court reaffirmed Chase's analysis of the Pennsylvania Constitution's in-person voting requirements. The Pennsylvania Supreme Court held that the Act of May 22, 1923, unconstitutional because the Pennsylvania Constitution still required electors to offer to vote in the district where they reside, and that those eligible to vote other than by personal presentation of the ballot were specifically named in the Constitution, i.e. active military. The court relied on two primary legal principles in its ruling. Number one, in construing particular clauses of the Constitution, it is but reasonable to assume that in inserting such provisions, the convention representing the people had before it similar provisions in earlier constitutions, not only in our own state, but in other states which it used as a guide, and in adding to or subtracting from the language of such other constitutions, the changes made deliberately and was not merely accidental. And two, the old principle that the expressions of an intent to include one class excludes another has full application here. The residence required by the Constitution must be within the election district where the elector attempts to vote. Hence, a law giving to voters the right to cast their ballot at some place other than the election district in which they reside is unconstitutional. These are still good laws. There is no challenge to these laws. They have not been, or good rulings, I should say. Valid case law. They have not been overturned. They're not contested. They're not cast into doubt. These are just valid cases. The court went further to note that, quote, however laudable the purpose of the Act of 1923, it cannot be sustained. If it is deemed necessary that such legislation be placed upon our statute books, then an amendment to the Constitution must be adopted permitting this to be done. This principle was affirmed between 1864 and 1924 in many other states with similar constitutional provisions, both with regard to absentee voting by regular citizens as well as by soldiers away from home. Article 7, 1 and Section 4 of the Pennsylvania Constitution have not materially changed since the Supreme Court struck down legislation unconstitutionally expanding mail-in voting in Lancaster City. While the Constitution has been amended many times, for purposes not relevant here since Lancaster City, the determinative constitutional provisions relied upon by Chase and Lancaster City remain either entirely unchanged or materially so. Previously numbered Article 8, Section 1 and Article 8, Section 8, those provisions were now found in the Pennsylvania Constitution as Article 7, Section 1, Article 7, Section 4. Article 7, Section 4 remains exactly the same as it did when the 1924 case was decided. Quote, all elections by the citizens shall be by ballot or by such other method as may be prescribed by law, provided that secrecy in voting be preserved. Article 7, Section 1 has only distinctly changed in three ways since the 1924 case. The voting age requirement was changed from 18 to 21. The state residency requirement was lowered from 1 year to 90 days, and Clause 3 of Article 7, Section 1 was amended to allow a Pennsylvania resident who moves to another Pennsylvania county within 60 days of an election to vote in their previous county of residence. None of these changes to Article 7, Section 1 have any material importance to the case at hand and were not relevant to this court's decision in Lancaster County. Now, you may have caught that the legal voting age in Pennsylvania under the Pennsylvania Constitution is technically 21. It is not 18. However, the U.S. Constitution supersedes that and has granted voting to 18-year-olds. So, there you go. Here we go. None of these changes to Article 7, Section 1. Oh, wait, no, sorry. Clause 3 of Article 7, Section 1 was amended to allow a Pennsylvania resident who moves to another Pennsylvania county within 60 days of an election to vote in their previous county of residence. None of these changes to Article 7, Section 1 have any material importance to the case at hand and were not relevant to this court's decision in Lancaster County. I think they mean Lancaster City. Pennsylvania Constitution thus remains, for all purposes relevant to the holding in Lancaster City, unchanged since 1924 with regard to the qualifications and requirements for voting in an election. Chase and Lancaster City are not only instructive to this case, but indeed are determinative as still valid presidential case law on the issues in question. Bad Vibe says, wait, so a ruling over 90 years old would be colloquially a super precedent? No, not necessarily. That would not be the only requirement. But these may be super precedential because there is no argument to overturn them. So post-World War II and the modern absentee voting provisions in the Pennsylvania Constitution. In 1949, the Pennsylvania Constitution was amended to also allow bedridden or hospitalized war veterans the ability to vote absentee. The Pennsylvania General Assembly began the process of amending the Constitution to allow civilian absentee voting in instances where unavoidable absence or physical disability prevented them from voting in person. Because of the restrictions and safeguards under Article 9, the 1957 amendment to the Constitution did not go into effect until 1960. The constitutional amendment effectively expanded eligibility for absentee voting to include only two categories of qualified electors. One, those who on election day would be absent from their municipality of residence because of their duties, occupation, or business. And two, those who are unable to attend their proper polling place because of illness or physical disability. Issues arose immediately with the canvassing and computation of ballots under the newly expanded absentee voting system, and any challenges to absentee ballots that were rejected by the Board of Elections resulted in the challenged ballots being placed with ballots that were not challenged, making it impossible to correct upon a subsequent determination that the decision to reject the challenge was incorrect. In response, quote, the legislature added further amendments by the Act of August 13th, 1963, to require the Board of Elections to mark any ballot that was disputed as challenged, hold a hearing on the objections, and the decision was opened up to review by the Court of Common Pleas in the county involved. Until all challenges were resolved, the Board of Elections was required to desist from canvassing and computing all challenged ballots to avoid the possible mixing of valid and invalid ballots. Sound familiar? They asked for this. They were told no. In 1967, following the Constitutional Convention, the Pennsylvania Constitution was reorganized in Article 7. Section 19 was renumbered to Article 7, Section 14. On November 5th, 1985, the citizens of Pennsylvania approved another amendment to Article 7, Section 14 of the Constitution, which added religious observances to the list of permissible reasons for requesting an absentee ballot. The 1985 amendment began as House Bill 846, which would have amended the Pennsylvania Election Code to provide absentee ballots for religious holidays and for the delivery of mailing of ballots. Let's see. considering HB 846 PN 1963, entitled An Act Amending the Pennsylvania Election Code, further providing for absentee ballots for religious holidays and for the delivery of mailing of ballots. In doing so, the Pennsylvania General Assembly recognized that because the Pennsylvania Constitution specifically delineates who may receive an absentee ballot, a constitutional amendment was necessary to implement these changes. This bill was thus changed from a statute to a proposed amendment to the Pennsylvania Constitution. This amendment is offered to alleviate a possible problem with respect to the legislation. The bill would originally amend the election code to expand absentee balloting. Because it appears that the Constitution talks about who may receive an absentee ballot, we felt it might be better in changing the bill from a statute to a proposed amendment to the Pennsylvania Constitution. On November 4th, 1997, the citizens of Pennsylvania approved another amendment to Article 7, Section 14, which expanded the ability to vote by absentee ballot to qualified voters that were outside of their municipality of residence on Election Day, where previously absentee voting had been limited to those outside of their county of residence. The legislative history of the 1997 amendments recognizes the long-known concept that there existed only two forms of voting, in-person and absentee voting, and that the 1997 amendment would not change the status quo, namely that, quote, people who do not work outside the municipality or people who are ill and who it is a great difficulty for them to vote, but it is not impossible for them to vote, so they do not fit in the current loophole for people who are too ill to vote, but for them it is a great difficulty to vote. They cannot vote under the 1997 amendment. Because the Pennsylvania Constitution has not been amended pursuant to Article 11, to allow for no excuse mail-in voting, the legislative efforts to authorize no excuse mail-in voting are fatally defective and inherently unconstitutional, having no lawful basis or effect. Citing Kramer versus Grant, the failure to accomplish what is prescribed by Article 11 infects the amendment process with an incurable defect. Sprague versus Cortes, holding that matters concerning revisions of the Pennsylvania Constitution require the most rigid care and demand nothing short of literal compliance with the specific measures set forth in Article 11. This amounts to a violation of both the Pennsylvania Constitution and the U.S. Constitution, the latter which, while granting the General Assembly plenary authority to enact laws governing the conduct of elections and for the appointment of electors, does not allow the General Assembly to violate the Pennsylvania Constitution in doing so. Finally, the other question. That was just the first question. I know these things get long. The Pennsylvania Supreme Court violated the First and 14th Amendment rights by depriving their right to vote in lawful elections, or by depriving petitioners of their right to vote in lawful elections and the right to petition without the requisite due process. So this is a different question. The first one is that the legislature made an unconstitutional law, and that violates the Elections and Electors Clause, making it facially unconstitutional to the United States Constitution as well as the Pennsylvania Constitution. This one says they're violating the due process rights of the 14th Amendment and the petition rights of the First Amendment by prohibiting their lawsuit via laches. Bad Vibe says, you know how many Dems see this coming during ACB's appointment, considering all the questions she was asked, requests for recusal, among other points, then hearing the rulings on similar issues smells fishy. Well, yeah. I mean, they're afraid of the Republican majority or the Republican appointee majority in the Supreme Court, especially in regards to this election. So, at least with respect to federal elections, the Pennsylvania Supreme Court was not free to deny the petitioners any practical means of remedying their injuries that were caused by the Pennsylvania General Assembly implementing no excuse absentee balloting in Pennsylvania by means of a statute rather than a Pennsylvania constitutional amendment. A fundamental requirement of due process is the opportunity to be heard. It is an opportunity which must be granted at a meaningful time and in a meaningful manner. Central to the principle of due process is a requirement that an individual be allowed a fair hearing before the government may deprive him or her of a protected interest. This court has held that the right of access to judicial proceedings is a component of the right to petition government for redress of grievances and is constitutionally protected. The right of, quoting California Motor Transportation Company versus Trucking Unlimited, the right of access to the courts is indeed but one aspect of the right of petition. Consistently, this court has reviewed such deprivation of access to the courts under a due process clause and equal protection framework. In body, this court found that the collection of fees and costs required to bring an action for divorce was a violation of the 14th Amendment's due process guarantee. This court noted that access to the courts is seldom an element of due process because courts are not usually the only available legitimate means of resolving private disputes. This court explained that where a judicial proceeding becomes the only effective means of resolving the dispute at hand, and denial of a defendant's full access to that process raises grave problems for its legitimacy. This court concluded, in short, within the limits of practicability, a state must afford to all individuals a meaningful opportunity to be heard if it is to fulfill the promise of the due process clause. Weighing the burden of the fees with the contravailing justifications for the fee, this court concluded that none of the government considerations were sufficient to override the interests of these plaintiff appellants. That's quoting one of the cases. So when a state fails to correct a violation of the state's constitution in the context of federal elections and fails to provide any avenue for relief for federal election challengers, it violates the U.S. Constitution. So the Pennsylvania Supreme Court foreclosed any and all meaningful review of the petitioner's claims. And this is true. It absolutely did. The Pennsylvania Supreme Court foreclosed any and all meaningful review of the petitioner's claims both before and after the election. Under controlling Pennsylvania law, petitioners were foreclosed from challenging Act 77 prior to the election occurring due to lack of standing. See Kaufman v. Osser. Appellants' interest in not having their in-person votes diluted by absentee ballots claimed to be unconstitutional had no standing prior to election because their interests were too remote and too speculative. Damn, that is right on point from the Supreme Court of Pennsylvania in 1970. So throwing the Pennsylvania Supreme Court's own words back at them. See also in R.E. General Election of 2014. This is the Pennsylvania Commonwealth Court. Appellant's assumption that allegedly invalid absentee ballots would vote in a way that would cause dilution of appellant's votes was unwarranted and cannot afford a basis for standing. So under existing Pennsylvania precedent, they did not have standing, so therefore they should not have known to bring their case prior to the election to avoid laches. Kaufman involved a challenge substantially similar to that brought by petitioners in the instant case. Plaintiffs in Kaufman, among other things, challenged provisions of legislation expanding absentee voting as being violative of Article 7, Section 14 of the Pennsylvania Constitution. The challenge was brought prior to an election taking place. In upholding the lower court's dismissal for lack of standing, the Pennsylvania Supreme Court held that, quote, the interest of appellants is not peculiar to them, is not direct, and is too remote and too speculative to afford them, either in their individual capacities or in their claim class representative capacity, a standing to attack these statutory provisions. The only conceivable way to make this harm adequately non-speculative and factually supported under Kaufman would be to wait for an election to take place. Unfortunately, as the instant case has shown, when the standing would otherwise be met when harm crosses the realm of speculative, laches is always a reliable crutch to lean on. Thus, under controlling Pennsylvania law, petitioners were required to wait until after the election to gain standing, and while petitioners promptly brought this action after the election, as soon as they reasonably could hire counsel and identify the constitutional infirmities of Act 77, the court below disingenuously retreated behind the facade of the amorphous doctrine of laches in order to deny petitioners their day in court. And this is a fundamental problem with laches. It's also a benefit of laches. And I'll explain what they're talking about here. So there are statutes of limitation, and those are very similar to the idea of laches, right? A statute of limitation says a case must be brought within a specified statutory set of time. And if the reasons we do this are because well, witnesses die, parties gain or lose money, witnesses forget things, evidence can be destroyed, all of that stuff. So we say there's a period of time beyond which we cannot bring a particular type of case. And there are different statutes for different types of cases. Notoriously, murder statutes, due to the gravity of killing someone, those tend to not have statutes of limitations in most, if not all, states. Consequently, a personal injury claim has a 2-year statute of limitation in many states. Sometimes it's a 6-year statute, depending on the injury. But that is because, well, you can get hurt by other things. So if I slip and fall and harm my back, somewhere, and I've got this back injury building up, then over the course of the next 6 years, I do a lot of skiing. Well, maybe I have exacerbated or caused other problems with my back. So we try to limit the scope of time. Laches has both a positive and negative element to it. The negative element is that there is no determinate amount of time where laches takes place. So you can't look at it and say, okay, I'm within the statute of limitations, I'm outside of the statute of limitations. Laches just happens, quote, whenever it's too late. The benefit of that is that sometimes it's too late prior to when a statute of limitations would occur. And this gives some flexibility to courts to say, yeah, but it's too late. It's too late. I know there's no statute of limitations on this, or there is a statute of limitations, but it's too late, and now there's no purpose in going through the litigation. But for me, a constitutional question about a federal election just should not have a laches defense applied. So that's what they're saying here. It's amorphous. It's you can't determine what it will be. It's within the whimsy of the judge. Okay, so the decision of the court below denied applicants access to judicial relief indefinitely, without adequate process and without deciding the issue of declaratory relief on the merits. Kelly versus Commonwealth, applicants plead for declaratory relief, asking for Act 77 to be declared unconstitutional, as well as injunctive relief and asking to prohibit the executive respondents from including no excuse absentee ballots in the final certified results of the election. Commonwealth Court granted a preliminary injunction pending an evidentiary hearing, finding that petitioners, demonstrated a likelihood of success on the merits. Before such hearings could be held, the Supreme Court exercised its powers of extraordinary jurisdiction, giving the court original and final jurisdiction over the controversy. Petitioners were foreclosed from bringing their claims in any judicial forum after the election when the Pennsylvania Supreme Court refused to consider petitioners' claims as to both the prior and continuing harms resulting from an unconstitutional Act 77 that remains standing law in Pennsylvania. Instead, the court dismissed petitioners' claims with prejudice on the purported basis of laches. The Pennsylvania Supreme Court went so far as to dismiss with prejudice petitioners' claim for a prospective declaratory relief as to future elections. In concurring and dissenting statement, Chief Justice Saylor pointed out the worrisome effect of the outright dismissal by the Pennsylvania Supreme Court. Quote, I find that the relevant substantive challenge raised by respondents presents troublesome questions about the constitutional validity of the new mail-in voting scheme. One of respondents' main responses is that the citizenry and perhaps future generations are forever bound by the legislature's decision to insert into Act 77 itself a 180-day time restriction curtailing challenges to the substantive import of the enactment. However, I find this assessment to be substantially problematic. Thus, appellees raise a colorable challenge to the viability of this sort of limitation, which can result in effectively amending the Constitution via means other than those which the Charter itself sanctions. So this is the doubly stupid part of Act 77. Part of the statute says that any challenges to the legality of this statute must be brought within 6 months, or else it's valid. Which on its face defies the Constitution of Pennsylvania, right? So imagine if we did that. Look, we're going to pass a law that says that you are not allowed to attend church. And we're going to impose a window of 15 days to challenge this law. And if no challenge to this law is brought within 15 days, it is valid law. Done. Period. Forever. Well, that would be clearly violating the Establishment Clause of the Constitution or the Free Exercise Clause of the Constitution. It'd be clearly violative of it. It would be unconstitutional. But because the law itself claims to supersede the constitutional amendment provisions, it's now constitutional. That can't hold. That cannot hold. Thus, res judicata attaches to the claims, and petitioners may not raise them in any other court. In the meantime, Act 77 remains in effect and unconstitutional, and petitioners continue to suffer their harms without any ability to obtain relief. Should petitioners want to raise the issue of constitutionality of Act 77 in 2021 in anticipation of the November 2022 election, res judicata would bar petitioners from raising the same facial constitutional challenges to Act 77. Notably, there are no countervailing government interests that necessitate barring any further challenge on these issues by applicants. Obviously, judicial economy is a compelling interest for res judicata generally, but that cannot justify barring applicants from reaching the merits of their challenge to a law that will continue to harm them. Petitioners were denied any opportunity to have their claims heard in violation of their federal due process rights and petition rights. Bad Vibe says, so wait, can how laches apply to other constitutional questions? It seems the situation seems odd, and wouldn't it apply to speech in regards to the kid with the Snapchat threats? In my opinion, laches probably shouldn't apply to facial constitutional challenges at all. Because if a law is facially unconstitutional, it's unlawful, it's unenforceable, it should be void and removed. To say that a law is facially unconstitutional, but too bad you waited too long is nonsensical. That just means that the Constitution isn't the Constitution. Tom531 Cat says, Nick, did Trump just win Wisconsin? Viewing this on courtlistener.com, case Feehan versus Wisconsin Election Commission, or am I misunderstanding it? Let me see. Let me pull up Court Listener. Let me see if I can find out. Can you give me, Tomcat, can you give me the case number for that? I'll see if I can pull it up on Pacer. Parties. Feehan. Search. It should show you on Court Listener. Let me see if, oh, I might be able to find it here. William Feehan. Do we have breaking news? Should be very interesting. Let's see. Gosh, I wish you could sort Pacer by date filed. This is the dumbest system. Oh my goodness. Here we go. Case number 220 CV177. Nine cases. Where? Why can I not find this? Eastern District of Wisconsin. William Feehan, Derek Van Orden. Complaint to the decertification challenge. This is what paralegals are for? No kidding. No kidding. They don't have the updated thing here. Let me see if I can find it this way. This work? Really? There we go. That's the Western District Court. Is this not on Pacer? Damn it. Maybe I can find it here. Search. Oh my gosh. I don't want opinions. Docket number. Search. Really? Oh, this is embarrassing. This one? I see this citation. This isn't what I'm... Supreme Court of Wisconsin. 4 hours ago. That's a response of proposed respondent. This is Trump versus Evers. Okay, so this is in the Supreme Court of Wisconsin. This is not the same case. You have a link to it? Aurora Alchemy, can you DM it to me on Twitter? Oh, here we go. Tomcat's got me. Right here. Thanks. Damn Chinese porn spam bots preventing me from actually just giving this. Text of proposed order. No, this is a proposed order. I don't think, unless this is signed. No, this is a proposed order, so this is not actually the a weird docket number. Great. Yeah, no. This is a proposed order. This is not an actual order that has been issued in the case. So, sorry to get everybody excited there. All right. All right. Going back to this. Yeah, proposed orders are very confusing, but you always got to look for a judge's signature on them. All right, here's their argument on laches. Pennsylvania Supreme Court erred, and then we're almost done. We're almost done with this. Pennsylvania Supreme Court erred in finding laches, and this court may review the error because significant federal interests are at stake, and the decision does not amount to adequate and independent state grounds. Pennsylvania Supreme Court's application of laches was erroneous and is subject to review by this court because significant federal interests are at issue. Present case concerns not only a federally created right, but a federal right for which the sole remedy is in equity. Unlike the situation where a court is situated in diversity jurisdiction and deciding an entirely state law matter, as presented in Guarantee Trust Co. v. York, in this action, this court has no duty to approximate as closely as may be state law in order to vindicate without discrimination a right derived solely from a state. Rather, the duty here is that, quote, of federal courts sitting as national courts throughout the country to apply their own principles in enforcing an equitable right created under the U.S. Constitution. In the context of a presidential election, state-imposed restrictions implicate a uniquely important national interest. For the President and the Vice President of the United States are the only elected officials who represent all the voters in the nation. That's quote citing Bush v. Gore. Article 1, Section 4 and Article 2, Section 1 of the U.S. Constitution impose duties and powers on the legislature of each state, as does the state's own constitution by the contours through which it provides the lawmaking power. Quote, a significant departure from this legislative scheme presents a federal constitutional question. The text of the election law itself, and not just its interpretation by the courts of the states, takes on independent significance in this court's review of such constitutional questions. Whether the state court has denied to rights asserted under local law the protection which the Constitution guarantees is a question upon which the petitioners are entitled to invoke the judgment of this court, citing Broad River Power Company. In determining its jurisdiction, this court must ask whether the question of laches is so intermingled with that of federal right that the former cannot be considered an independent matter. This is so for state election laws governing the conduct of federal elections. Quote, the adequacy of state procedural bars to the assertion of federal questions we have recognized is not within the state's prerogative finally to decide. Rather, adequacy is itself a federal question. Lee versus Kemna. And then the quote there is, whatever springs the state may set for those who are endeavoring to assert rights that the state confers, the assertion of federal rights, when plainly and reasonably made, is not to be defeated under the name of local practice. As a threshold matter, it is the duty of this court to ascertain, in order that constitutional guarantees may appropriately be enforced, whether the asserted non-federal ground independently and adequately supports the judgment. Here, it does not. Federal jurisdiction is not defeated if the non-federal ground relied on by the state court is, quote, without any fair or substantial support. Quote, state procedural rules have been held insufficient to bar federal review if they are not strictly or regularly followed, or if they are novel and unforeseeable, or if they impose undue burdens on the assertion of federal rights. Roosevelt Kermit III, Light from the Dead Stars, a procedural, adequate, and independent state ground reconsidered. Let's see. The reliance on laches by the court below fails to meet the sufficiency needed to overcome each of these historical grounds. This court has often pointed out that state procedural requirements which are not strictly or regularly followed cannot deprive it of the right to review. Laches, as applied to the case below by the Pennsylvania Supreme Court, is entirely inconsistent with that court's consistent historical precedent and is contradicted by the court's recent practices in hearing analogous substantive constitutional challenges. That is a fantastic section. I'm going to snip and save for later. Take that. Laches may bar a challenge to a statute based upon procedural deficiencies in its enactment. However, in Stilp, the court found that appellees conceded that laches may not bar a constitutional challenge to the substance of a statute. Fucking thank you. That's what I said. Yes, when this happened. That's what I said. How can laches bar the facial constitutional issue? It doesn't make sense. It doesn't make sense. The holding in Stilp contradicts the Pennsylvania Supreme Court's holding in the instant action. Stilp teaches that while the principle of laches may apply to a constitutional challenge on procedural grounds, it does not apply with respect to the substance of a statute. Stating that laches and prejudice can never be permitted to amend the Constitution. Fuck! That is beautiful. Now I gotta add this to like a MS Paint thing. So I can have multiple copies or multiple things. Hold on. Oh my goodness. Whoops. 1 second. I don't want the little highlight on there. Copy. Man, that's good stuff. That's good stuff. That's some fine lawyering right there. Mighty fine lawyering. Petitioners' constitutional claims are substantive and therefore cannot be defeated by laches. Unlike Stilp, where the plaintiffs argued that a bill was not referred to the appropriate committee and that the bill was not considered for the requisite number of days, here petitioners argue that the substance of Act 77 directly contravenes the Pennsylvania Constitution. This is important because the constitutional amendment is separate from Act 77. Constitutional amendment is Senate Bill 413. If the constitutional amendment was within Act 77, they might have some issues here, but they're not challenging the constitutional procedure of Senate Bill 413. They're challenging the fact that Act 77 was passed prior to the constitutional amendment of 413, which is not passed yet. It has not been passed and cannot take effect. Petitioners make no challenge to procedural mechanisms through which Act 77 was passed, bicameralism and presentment, but rather what is substantively contained within the legislative vehicle that became Act 77. The Pennsylvania General Assembly attempted to unconstitutionally expand absentee voting through Act 77, despite constitutional limitations to such expansion. Act 77 itself is not a constitutional amendment, which would be the type of procedural laches challenge raised by the executive respondents and would fail in any case. Maybe. Such a patent and substantive violation of the state constitution cannot be barred by the mere passage of time. Quote, to so hold would establish a dangerous precedent, the evil of which might reach far beyond present expectations, citing Wilson. Amending the Constitution to expand a protected and fundamental right is not a mere procedural step, but rather one of substance. This section is beautiful. Now, it doesn't mean they're going to win. This is just good. This is good legal writing. This is very well established. It also agrees with what I said, which makes it better. Automatically makes it better. All right. Even assuming arguendo that laches could apply to retrospective relief in a substantive constitutional challenge, laches can only bar relief where 1, a delay arising from appellant's failure to exercise due diligence, and 2, prejudice to the appellees resulting from the delay. Let's see. In Sprague, the petitioner, an attorney, brought suit challenging the placing on an election ballot of 2 judges. Respondents raised an objection based on laches because the petitioner waited 6.5 months from constructive notice that the judges would be on the ballot to bring suit. In evaluating the facts that the petitioner and respondents could have known through exercise of due diligence, the court found that while the petitioner was an attorney and was therefore charged with the knowledge of the Constitution and laws, the respondents, the governor, secretary, and other Commonwealth officials, were also lawyers and similarly failed to seek timely relief. Oh! That's interesting. In denying the laches defense, the court reasoned that, quote, to find that petitioner was not duly diligent in pursuing his claim would require this court to ignore the fact that respondents failed to ascertain the same facts and legal consequences and failed to diligently pursue any possible action. What? That is beautiful again. Look at that. Damn. So what they're saying is, well, yeah, you had a duty to find it out. But the other party had a duty to find it out too, and just because they didn't bring the challenge and didn't raise the constitutionality to their own benefit, that shouldn't attach to them. To be clear, a citizen with an actionable claim cannot just wait to file a grievance it is aware of. However, courts will generally, quote, hold that there is a heavy burden on the respondent to show that there was a deliberate bypass of pre-election judicial relief. The executive respondents were never required to meet that burden here. There's no evidence or reason to believe that petitioners deliberately bypassed pre-election relief in the instant action. Unlike in Sprague, petitioners here are not lawyers. They did not know, nor could they have been reasonably expected to know, that they had viable legal claims well before the election occurred. With respect to the candidate petitioners, none are members of the state legislature, and none have responsibilities with respect to Pennsylvania election code or its constitutionality. Conversely, as in Sprague, Respondent Bookvar is an attorney and should be charged with the knowledge of the Constitution and particular knowledge of the election code. In Sprague, the taxpayers' more than 6-month delay in bringing an action challenging the election did not constitute laches, thereby preventing the Commonwealth Court from hearing the constitutional claims. Additionally, respondent Pennsylvania General Assembly appears to have had knowledge of the constitutional issues involved and began the process of amending the Constitution to allow no excuse mail-in ballots. That process appears to be ongoing to this day. Here, this is great. This is a good footnote. If Act 77 is not declared unconstitutional, and if when the amendment purporting to allow for no excuse mail-in voting is voted upon by the electorate, that ratification process will utilize the very no excuse mail-in voting the amendment seeks to authorize. In the meantime, the entire Pennsylvania electorate has been disenfranchised of their right to vote on amending their constitution to grant authorization for no excuse voting by mail. What a great paradox it's created, that you can use the provisions of the law to pass the law you're going to use the provisions of. It's a legal impossibility. This is why I liked this case from the start, and why I'm so pissed at the Pennsylvania Supreme Court for how they acted, because look at this. I mean, there's no other way to read this law as other than violating the Constitution on its face. I get what Uncivil Law was saying the other day, where he could read it as comporting with the Constitution. And I agree on its face you can read it that way, but I don't think you can do so in context of the historical decisions. Unless there's a citation that shows them doing otherwise, which presumably we'll see in the response. In short, the Pennsylvania Supreme Court charged petitioners, who had no specialized knowledge, with failure to institute an action more promptly, while respondents possessed extremely specialized knowledge and failed to take any corrective actions. Petitioners did not hedge their bets. They simply brought an action within mere days of gaining enough information to know they had been harmed by an unconstitutional election. As soon as they reasonably could have hired counsel to research and identify the constitutional issues, and after they gained standing to bring their claims. They did not even wait for certified election results to confirm that they had been harmed. An interesting point that most of the times to contest an election, you would have to wait for the certification. Here they're saying they didn't even wait. In many cases, you would be required to. Let's see. It could not have in any way served the petitioner's interest in this matter to delay action for even one day. To suggest they did so deliberately is unsupported. Respondents' collective failures in enacting Act 77 or to remedy its constitutional problems at any point puts the weight of any necessary curative disenfranchisement squarely on their shoulders. Laches is a shield to protect respondents from gamesmanship. It is not a sword to use against harmed individuals to insulate respondents' unconstitutional actions. It also bears noting that both Chase and Lancaster City involve substantive constitutional challenges to legislation expanding absentee voting. The legislation challenged in Chase was enacted 23 years prior to its decision. And in Lancaster City, the legislation was enacted 1 year and 2 months prior to its decision. In both cases, the constitutionality of the legislation at issue was challenged after the election had occurred. In both cases, mail-in ballots that violated the state's constitutional prohibition were not counted. Meanwhile, this action challenges legislation passed on October 2019, amended by legislation in March 2020, and further amended through the Judicial edict 1.5 months prior to this action being commenced, by the same court refusing to hear this challenge. Pennsylvania's Supreme Court arbitrarily applied a new, unique, and surprising version of the laches doctrine to the constitutional challenge in this case. Further evidence of the irregular application of laches by the Pennsylvania Supreme Court can be found by examining recent substantive constitutional challenges to legislative enactments in the state. Pennsylvania Supreme Court, as recently as 2018, decided a challenge to the state's congressional district plan brought 6 years and multiple elections after the 2011 congressional redistricting map legislation had been enacted. On November 23, 2020, well after the election had already taken place, Pennsylvania Supreme Court heard another case regarding whether Act 77 required county boards of elections to disqualify absentee ballots, including no excuse absentee ballots, based on the lack of a signature on the outer secrecy envelope. They didn't time bar that one by laches. They heard it. Wonder why. Wonder what result they came to. As in NAACP, here, there is no reconciling the procedural holding of the Pennsylvania Supreme Court in the present case with its past unambiguous holdings. Thus, not only is laches here an inadequate state ground for this court to abstain review, but the Pennsylvania Supreme Court's application of the doctrine was used as an offensive sword against petitioners to avoid addressing the merits of a federal question of fundamental importance. Boom. Boom. That is good stuff. For the foregoing reasons, this court should grant the request for an emergency writ of injunction, or alternatively a stay of lower proceedings, grant cert on the questions presented herein, treat the application papers as a merits briefing, and issue a merits decision as soon as practicable. Greg Tufel with a mic drop. That is a fantastic document. Is a fantastic document. That third argument on laches really slaps shit all over the Pennsylvania Supreme Court, and does so by using the Pennsylvania Supreme Court, which is beautiful. Beautiful to do. So this is merely a petition. The United States Supreme Court is under no obligation to hear this case. Unfortunately, that could prove fatal to it. They have a friendly-ish justice, Saul Alito. They have Alito as the justice, and he may hopefully provide the injunctive relief requested and put it to a vote for cert to see if they'll take the case. I think this is a much better case than the Giuliani case. I mean, again, the plain interpretation without all the mushy feely shit is to say that this is invalid, it's unconstitutional, and the votes cannot be counted. If they do that, Trump wins Pennsylvania handily. So we'll see. Now, is that enough to flip the entire election? No. Are there issues, however, in this case that could have an impact on other states? Yeah. There's still at issue the question of whether, I mean, it's in this case, it's combined in other cases, of whether or not the Secretary of State could, or the state Supreme Court could expand the window for mail-in voting. That's a question of whether or not they could do that. And that particular question wouldn't have huge impact in Pennsylvania, but it may have severe impacts in places like Georgia, Wisconsin. I don't know. I don't know if it does or not, but it could. Georgia, Wisconsin, North Carolina, so Michigan, maybe. Those are interesting and separate questions. So that is Pennsylvania. It is the one I've been watching, mostly because I think Pennsylvania is a critical win. They have to win it. If they don't win Pennsylvania, I'm not sure they're able to get enough electoral votes, even if they were to win the other states. They have to take away, 36 votes? 37 votes? Pennsylvania's 20. So they would have to win. Without Pennsylvania, they'd have to win quite a few. This case is, it's a really good shot. I maintain my original analysis that I think this is the best shot they have in Pennsylvania. It's still hard to see a court will overturn the votes of so many. However, that's only because of modern conversations about votes. Now, promising stuff. Amy Coney Barrett was criticized in her hearings for having for determining that, you know, a vote is a civic right as opposed to a personal right, even though she didn't actually do that. She was just citing the originalist language of other cases and of other courts. But that is potentially a concern, right? If it's a civic right and not an individual personal right, then that civic right is more subject to the Constitution and less subject to the sensibilities of the individual. You're not disenfranchising an individual by depriving them of a civic, or by not allowing the improper usage of a civic right. So, NW Backcountry, our country does not recognize voting as a natural right. No. Because our right to vote, our individual right to vote was conferred, it's conferred by state legislatures in determining how they pick electors. So, that is, yeah. Anyway, so that's what I've got for you guys today. I mean, we've got some chats to read through. But I know it's always like an endeavor to read through a dense petition or a dense opinion, and especially adding in that 1800s case, the language gets a little bit tricky. Not tricky, it's just soupy, you know? It's just like kind of laborious to read through it. So I do appreciate you guys hanging out with me. You know, this thick stuff to get through, and getting through it very quickly is tough. Laches claimed in Wisconsin response as well. Which response? They're challenging the certification. They had to wait until it was certified in that one, unless it's a different Wisconsin case. But yeah, if you guys, as a parting thought, if you want me to drink coffee whiskey, which I will probably hate because I don't like coffee at all, you have a couple minutes to get the likes over 1,000. Right now, there's 130 to go. So if you want to see me suffer, that is one way to do it. And I'll drink it slow just for you guys. Over on Twitch tonight, there will not be a movie. I'm not going to do a movie tonight because I have been neglecting a portion of my Twitch audience, which is the video game audience, who come to hang out and cannot watch the movies due to being in other countries. So I will probably be playing a game or multiple games. I'm not sure. Son of a bitch. I will be playing a game or multiple games. So this is Jameson Cold Brew. Here you go. Whiskey and coffee. Oh, it says with notes of toasted oak and dark chocolate. Weird. They left out shit. Oh, it even looks like coffee. Ah! Oh, it smells like coffee. Okay. Guys, I've hated coffee since I was a child. The smell of it. It was the one thing I hated about going to my grandparents' house. My parents didn't drink coffee. My grandparents did. And that smell, I mean, they drank a lot of coffee, and that smell, that fucking smell. It brings up everything bad I remember about my childhood. Oh! Ah! Oh! I can't get rid of it. Oh, it's just the... Okay. Oh, it just tastes like I ate a fucking pile of coffee ground up grains. Ah! Oh, God. It's nasty. And it just sits there because it's whiskey. Every breath is coffee. I don't have a chaser. I still have this much left. Gargle it. Oh, you're going to have to pay for that privilege. I am, at the end of the day, an e-thought. I will not gargle things without my chatterbait dues, buddy. Ugh. Ah! Oh, God. Ugh. I need a minute. I'm going to start reading the chats. Every sip of this is fucking depression put into liquid. How much to gargle? Make me an offer I can't refuse, man. I'm not going to put a price on that shit. Hated 7 Days to Die says, hey, Nick. My father passed away last Thursday. Stressful times ahead now. Thanks for almost always having a show for me to watch in the morning. Hey, man. Sorry to hear that. You know, I know it is going to be stressful times, but focus on the good things you remember about your dad and the good stories of him. Question says, Tim Pool keeps saying, if it goes to House delegations, Trump likely wins. Would you agree with that statement? From the happenings, Republicans do not seem to back Trump too much, but rather actively work against him in many cases. The thought about Trump winning at delegations is because there are more Republican majority House delegations than there are Democrat majority House delegations. Whether or not it'll work that way, remains to be seen. It remains to be seen. Republicans having to have a spine is, oh God, is always a risk. I have a little bit of old Dr. Pepper. Ah! Oh, it's worse. Okay. So maybe. $100 to gargle a full shot? I mean, if you want to pay me $100 to gargle a shot of whiskey, I'll do it. That's up to you. Bunny Bootsink says, can you cover the drama that happened between Games Journals and Arch around Studio Foe and Wargaming, along with the potential contractual interference done by those at PC Gamer? Yes. I do plan on covering this. Ideally, I'll be reaching out to Arch. I had talked to him a long time ago about coming on the show, and he didn't seem closed off to it. So ideally, I would love to have him on the show to talk about it. But I will reach out to Arch and see if that's a possibility. We could talk about that, and then we could just talk about Warhammer and gaming and culture. I like him. I know some people don't like him. That's fine. I like him. I like his content, and so I'd be happy to talk to him. Just in general. But, yeah. So, yes. Short answer, yes, Bunny Bootsink. I would love to cover that case. Or cover that issue. Archman bad. Would Moldy Milo's tea be better? Maybe. This is nasty. Mario Carter 13 says, Beyond two pronouns, starring Abby from The Last of Us 2. Bad Vibe says mainstream media today, everything you know is wrong. Black is white and short is long because everyone you know is wrong. Twilight Dragon 3 says, here's some good news. The Game Theory channel was able to raise over $3 million for St. Jude's Children's Research Hospital. Good. I'm glad. Shadows King, that was a border prince. A border prince. I need to talk to him again. He's a good dude. Automata says, this super chat given in amazement that Nick made effective use of the community tab and linking to Vic's Twitch channel. How very non-boomer. Solemn says, no bad news. I was nuked off Twitter for asking if the guy that said gender reveals are violence against children was started. Oh my goodness. Automata says, what do you say to your critics who claim that pivoting from the elections to directorial shows is you continuing to hand out the very blackest of pills? Look, I don't hand out the black pills. I facilitate the black pills being handed out to you from Drexel himself. Serial Foxity says, CAPTCHA wants you to click on all images with a grifter in it to prove you're a human. But what if I'm a lawyer instead of a human? Oh, that I could tell you a quick funny story. So I had a very, very short criminal hearing today. Very simple issue. Resolved it for a client for the most part. There's a little bit more left to resolve, but nothing crazy, just some procedural stuff. Which is why I was up really late last night. However, I had the opportunity to talk to the prosecutor, prior to our hearing and figure out how this was going to go. And I had given the prosecutor my phone number on the Zoom call with the court, but it must not have come through correctly. And so one of the digits he had was wrong. So I'm sitting there waiting for his call, and he wasn't getting through. So I looked up his phone number and gave him a call at his office, which I'm glad he was at his office. So I called him, and then we, figured out the phone thing or whatever. But then in the meanwhile, he was trying to find my phone number. So he Googled me. And then what does he find? Of course, is the channel. And he's like, he says, yeah, I was just checking out your videos where you drink whiskey and explain the law. That's great. That's something that speaks directly to me. And I was like, oh, yeah, it's great now. And I was just really glad that he didn't get to one of my rants where I said something akin to the only humans worse than lawyers are prosecutors as a subset. So, buddy, if you're out there, it was great talking to you. I say it only in love of what prosecutors have to do. And I would definitely have a shot of whiskey or a couple glasses with you and chat. So I will independently hit you up because I think we could have a good talk. So he's super nice though, really nice guy, and seems to be, the thing with cops and prosecutors is they have a disproportionate ability to ruin someone's life, and so the good ones are fine. The bad, whoa. Oh, damn it. The good ones are fine. The bad ones taint the name of all the good ones. All right. Philip Callan just put up a large donation. He says, gargle it like a cam girl. Let's see that drool down the corners of your mouth with those soulless eyes. Kermit, if you please. Oh, you want me to? Okay. Gargle it like a cam girl. Let's see that drool dribble down the corners of your mouth with those soulless eyes. That's disgusting. That is disgusting. How dare you? Let me put napkins on my lap in case I do gargle some out. Everything about this I hate. There's not enough. I think there's not enough in here to merit that donation, so I will. Look, I'm not above it. Just need to tip it up a little bit. I'll show you the amount we got. So now we're up to this level of disgusting. Pop it up all the way. That would kill me. All right. Here we go. I don't want to do this. Oh, God, the smell. Sorry. I couldn't dribble it out. Oh. Oh, God. I've promised to never cry on camera. Oh, my childhood. My grandparents on my dad's side remembers the Knights of Columbus in Houston. And, oh, God. I remember going with my grandma. My grandma was in charge, I think, in charge of the kitchen. You know, the ladies of that supported the Knights of Columbus, because the Knights of Columbus, I believe, is all men, and then they had the Ladies Auxiliary. That's what it was called, the Ladies Auxiliary. You know, as has been proper for all of human time, the women would cook for the men. Unless you're grilling, which they were not. Oh, God. Every breath. So, I would go with my grandma to the Knights of Columbus Hall. And, I'm going to chase this with some gin. I would go to the Knights of Columbus Hall with my grandma, and she would, you know, work in the kitchen and get things ready and organized for their events and stuff like that. And one of those things was to make sure there was coffee, you know, and they had that big fucking pot of coffee and those giant coffee filters. And I remember having to change them out sometimes and like throw them in the garbage, and that rank, like putrid coffee filter that's been sitting there for, you know, a day. That smell like coming up out of the garbage can. That's in my mouth. That's in my mouth right now. Oh. Oh, God. Philip Callan, cheers to you, buddy. Thank you. It's appreciated, even though I hate it. When the gin goes down like water because the other taste was so bad. Oh, God. Oh. Oh, I hate everything about this. Okay. Perpetuous Augustus says, do you think NASDAQ's board of directors diversity mandate will stand? Mandatory one woman, one non-white. They just asked the SEC to approve their plan. God, I hope not. What a terrible thing to impose. Racial and gender-based hiring is the antithesis of good. Oh, God. Pet says an hour ago, Trump will veto NDAA unless Section 230 is killed. Andrew Young says, I refuse to sign my job social media policy. I knew I had to cover myself. Please give congrat that I came out as transgender. A two-spirited and non-binary individual with the pronouns he and haw. I'm Canadian. Andrew Young, you're a beautiful shim, or well, a hee-haw. You're a beautiful hee-haw, and I believe that your brave stance is beautiful, and never let anyone hold you back. Wacky Boy says, as Kermit, please just say you know you won't be satisfied, not unless you know your name is verified. God, I hope you choke on hate and stomach bile, even as you sing the praises of feticide. What is that? Chris M says, running late, so I won't hear an answer until you're finished streaming. What's wrong with being a centrist? I'm usually good ideas over partisanship. Cheers. There's nothing wrong with being a centrist. It's just people call them filthy centrists. I'm on the list of filthy centrists in that research paper that's circling around. I was very sad when I read through the names of far-right people because I was like, how didn't I make the list? I'm bigger than some of these other channels. And then I realized I did make the list. I was just not where I figured they would put me. So, very interesting. Very interesting. Hyrule 47 says, you going to Road Rage? Road Rage Tampa? Yes. My tickets are booked, and I am there. What time does it start? I don't even know. I think it's on Saturday, but the partying starts Thursday, in my opinion, because that's when I get there. I get there Thursday, so the partying starts Thursday for me. And the partying ends Sunday when I go home. Daniel Carmago says, SCOTUS sends case to legislatures. They choose electors. Electors abstain / vote Trump. House delegates vote Trump in January 20th. The ultimate white pill. It's a possibility. They need more than Pennsylvania. They need Pennsylvania and 2 other states. But if they do it, it'll be a legendary victory. Daniel Carmago says there was no standing in 2019. Sean has standing now. Supreme Court of Pennsylvania laches is irrelevant now. SCOTUS will hear case and give legislatures power like in Bush versus Gore. I don't know if they will, but they can. And that's something bigger than anything we've seen so far. Man, after drinking that coffee, I can drink gin all day, apparently. Perpetuous Augustus says, isn't it cuck that we leave things like laches up to the individual judgment of the products of modern law schools? Yes. Javier Miedo says, is it possible for electoral college reps from a state is deemed invalid the day of electoral congregation? Theoretically, maybe. I don't know how. I don't see the constitutional way for a court to do that. I think once the votes are cast, which I think is December 15th, either the 14th or the 15th this year, I think once the votes are cast, they're cast. Bad Vibe says, this feels like great white pilling to me. It might be. I'm trying to be cautiously optimistic on anything. I don't want people to think I'm out here rah-rahing, saying we're going to win. The odds are overwhelmingly against Trump and have been. But to that point, I want to point out, just pointing out that the odds aren't great. Odds are odds. Really, odds always boil down to 50-50, right? Like, the odds don't give a shit if you win the Powerball and take home $800 million. Didn't matter what the odds were. At the end of the day, you won. That's how odds are. Odds are the likelihood of success from an external perspective. But the odds never consider the fact that your Powerball ticket has the winning numbers. That's the question. Does your Powerball ticket have the winning numbers? Well, if it does, your odds are 100% of winning. So, that's statistics are not predictive of outcomes. They're predictive of probabilities. So that when I say that he has long odds, and long odds aren't no odds. It's very possible that it happens. But I'm also not going to be the here's how Bernie can still win guy, because, theoretical possibilities, until they manifest more directly and concretely, It's not worth exploring all of them. This one, I think, has a real chance of winning at the Supreme Court if they hear it. That doesn't even mean Trump wins. That just means that Pennsylvania goes into question. It could be real good for Mike Kelly, Sean Parnell, those guys. Those guys could win elections that they otherwise would lose, even if Trump doesn't win. And that, for them is very, very important. So there's outcome there even if Trump doesn't win. But, we'll see. Bad Vibe says, suffer, boomer. Thank you. Nardo Polo says, you drink that swill, drink it all up. God, it's gross. Sky Hime says, slower, drink it slower. Gunnar Renee Oy says, drunk 3PO had a cinnamon maple coffee beer at Epcot. He kind of made a face drinking it. That sounds gross to me, too. Bad Vibe says, gargle boomer, grift suffering. Reverend Brandon War says, next episode of Fear Factor, Rackets versus Tyrone Biggins. Bad Vibe says, this secures his championship for Grifter 2021. Kolfe 2A wannabe Hunan Muhammad says, time for toilet sama. No, I do need to eat or drink something to soak up this taste because it's just nasty. The gin isn't fixing it. Biden the Cold One says, love you, Nick. If I'm ever feeling down, all I have to do is watch you drink yourself into the ground. Oh, thank you. And Joseph Kerwin says, next time you sip the coffee whiskey, make an ahagio face. Agaheo, whatever. Tongue out, eyes rolled up, and a bit of coffee whiskey leaking from your nostril. Oh! Foreign 42 says, any result based on probability is always 50-50. Either it happens or it doesn't. Also, 94.347% of statistics are made up. Coming out your nostril? That's disgusting. That's disgusting. All right, guys. I'm going to play that outro. Hey, come over on Twitch if you want to hang out for a little bit longer. Like I said, I'll be doing a little bit of gaming. Emphasis on the gaming. Just kidding. Thinking about playing some Skyrim or something else. I don't know. Come check over there, and we'll play some Vidya for fun, and then that'll be a good time. And then we'll see you guys tomorrow, hopefully, with Drexel. I think he said he's coming out. So we'll see. Thanks, guys. I'll see you then. Have a good day. Peace. Peace. Where's the mute for the fucking thing? Here we go. Peace, peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some law-splaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes madder, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an Ardbeg, a Balmore, a Lafroig. The spirits flow as the ones who get unemployed. So pour out a glass for the team post on Twitter as we hear law-splaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all planet folks from Dundee to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. out an Ardbeg, a Balmore, a Lefroy. Spirits flow as the ones who get unemployed. So pour out a glass for the tea, post on Twitter as we hear Lost Planning tonight. From the white shores of Nairn to the hills of Glenlivet, there's no